right, good morning, everyone. Let me know if you are able to, one, see my screen, and two, if you are able to hear me. You can type in the chat. Okay, good. So we'll get right into it. Just give me 1 second. Okay, all right. So my name is Sandrine. I am a second-year student at the University of the West Indies Mona campus, and I will be your presenter for the first half of the session, which is paper 2. And Samoya is another person, you have seen her in the group. She is another law student at UWI, and she will be conducting the paper 1, which is the multiple choice section. All right, so before I get into the meat of the matter, I really want you guys to get some general tips. I think it's essential. So I want you to know that when you are answering your questions, you may get 2 different types of questions. I am thinking your lecturers or teachers would have gone through this already, which is the fact that you have a problem question and you have an essay question. You have a problem question because normally, well, it's really the best thing for lawyers. For unit 1, they tend to give you a lot of essays, but when you get to unit 2, and if you decide to continue in law, you may see more problem questions than usual, because when a lawyer goes into court, they cannot spend sometimes more than like an hour or 30 minutes doing a presentation if they get that long, and they have to just get to the point. Getting to the point means you have your issue, your rule, application, and your conclusion, and that's where it ends. But if you're writing, and you may get an essay, well, more than likely you're going to get essays, as I said, in unit 1. So if you're doing a problem question, you wouldn't have an introduction and paragraphs, but if you're doing an essay, you should write your essay like you're doing, like when you do your literature essays or sociology or communication studies or Caribbean studies, where you have your introduction and your body paragraphs and your conclusion, which is what I have here. So I don't have to go over that. Oh, well, I have here that how do you tell the questions differently? If you see define, explain, examine, discuss, that is an essay. But if you see where it says to advise the parties or advise the parties, then it is usually a problem questions. I had a question, sorry. I had a note here that your questions are now mandatory. And because when I was doing CAPE some years ago, when I did unit 1 in 2018, we had a choice. So when it comes to module 1, we would have like 2 questions on a module 1 from 2 different topics. And it's the same for module 2 and 3. But in your case, it is mandatory, and therefore I advise you to not only try to say, oh, I am going to do an essay, so I'm going to learn how to do an essay, or I'm going to do a problem question because I'm going to learn how to do a problem question. What I have noted, and you will see closer to the end of the session with the more recent CXC papers, that what they now do is that the question have 2 parts, a part A, which is an essay, and a part B, which is a problem question. So, and it's 1 mandatory question divided in 2 parts. Therefore, if you're going to get the maximum of the 25 marks, you will have to. Someone is saying something?
What?
Okay. So if you're going to get the maximum of all the marks, you will have to do both problem and essay questions. All right, so I have some objectives here for this tutoring session. At the end of the session, students should be able to explain briefly each broad topic. Students should be able to answer a problem question using the IRAP method, and you should be able to solve some past paper questions that will go through both essay and problem. So the first module that you do in unit 1 is Caribbean legal systems, and looking at your broad topic release, which I think is very fortunate for you guys, because as I said, we would just get a bunch of topics, like about 6 topics, and we'll just have to answer what we're more comfortable with, and we just have to study everything, and we're not really sure what's going to come on the exam. But with you, I'm guessing because of the situation that we're in with COVID and everything, CXC have given you the broad topics, and which is why I had said in the group that when you are doing your past paper questions, nothing is wrong with doing a 2021 or 2020 past paper question, but I do advise you to seek past paper questions that fit with your broad topic, because it really makes no sense you study or you go through past paper questions with about 6 things and none of them deals with classification of law, because then you will only go into the exam knowing how to write or how to answer a question, but not necessarily how to answer the topic. So the first topic, or the topic that I see for module 1 on your broad release sheet is classification of law. Now, according to the syllabus, students must focus on the following areas: reasons for classification and classification basis. On the classification basis, you must focus on subject matter, functional, and conceptual. Now, can anybody tell me what is classification or classification of law before I proceed? Great. I'm hearing you, so yes.
Okay, well, essentially, classification of law is the groups in which the different functions, concepts, and subject matter of the law is divided into. So whether it be, okay.
Go ahead, continue, sorry.
Oh no, I'm finished. It's okay.
Oh, okay, thank you. That's very good, and that is correct. So classification of law really refers to the different areas of law, or as your colleague would have said, how it is grouped. The reasons for classification, are in other words, why it is necessary to have different areas of law is so that we don't really get confused. I have something here that I got from a Harvard Law Review that I think may be essential. It says that classification is the shaping and developing of traditional systematic conceptions and traditional systematic categories to organize the body of legal precepts so they may be, 1, stated effectively with a minimum repetition overlapping with minimum, it shouldn't be there. It should be with minimum repetition, overlapping and potential conflict. 2, administered effectively. 3, taught effectively. And 4, developed effectively for new situations. Now, I had a note here, which is that there's a whole thing about scientific versus legal classification, because really and truly, classification takes on sort of a scientific module where you have like your different observations and your hypotheses and everything. But we won't look at that because that's not necessary for where you are now. Maybe if you do proceed to the university and to do law and as your major, you may see all of this debate in both science, medicine, and technology, and you will also see it in law and legal systems, but it's not necessary now. So making the explanation a little bit easier, I had a list of things here. Classification allows us to know where to conduct research, and that will help us to solve specific issues that we are presented with. I had something here that I won't visit criminal law cases for issues on property. Now, that's essential because if we don't know if the law is not classified, if it's not grouped into different areas, now remember, when a client comes to a lawyer, they don't come and say, oh, sir, I have an issue in property, or oh, sir, I have an issue in tort. A lot of your clients won't even know what is tort. So they will come to you and say, oh, their neighbor is bothering them and making noise at their head. If you can help them to get support so that their neighbor can be arrested. And based on classification of law, we all know that if it's an issue with civil persons or with persons, not civil persons, if an issue between 2 individuals, and not an individual and the state, then it would be a tort or a civil matter and not a criminal matter. So the person wouldn't be arrested. They would probably can go to court and get some form of remedy or damages. But if we had no classification of law, a lawyer would possibly go to court and argue a tort matter as a criminal matter. So, and then secondly, I had it here that clients, attorneys, judges know under which subject matter the law will fall and where redress may be sought, which is what I explained a while ago. And then I went to the fact that it clearly defines the relationship between two or more areas. This is essential because, as I gave in the example a while ago, tort and criminal law are so close that it's easy for people to like get them mixed up. Because assault and battery is in criminal law, assault and battery is in tort law. When we talk about negligence, we talk about gross negligence under criminal law, we talk about negligence under tort law. So it is important that the law is classified so that areas that are so close, and then as you get to university, you will learn about property. Well, you'll learn about property next year, but as you get to university, you'll start to see where you will have other courses that are close to property, like property equitable remedies, and you don't want to get confused because they're really two different things, although they're close, and I call them cousins or twins. And you'll see that you have other areas of the law like human rights and international law, and they all coincide. So because the law is classified, lawyers, judges, everyone who deals with the law is now able to say, even though these areas may be twins or cousins, we can separate them and know the correct area under which redress may be sought in court. Classification basis: subject matter, functional, and conceptual. Subject matter. Now the law can be classified, and you would have seen the examples on your syllabus or on your broadsheet, which speaks to contract, criminal law, and tort. These are examples of subject matters. There are many other subject matters. As I said, real property, I talked about international law, you have constitutional law, many other areas. I have here, law can be classified based on the subject matter. These are the areas of law that we study and practice. And this is a reason why you have attorneys specializing in specific areas. Now, so if you see something regarding sentencing or someone being, locked up or anything of the sort, or it's criminal law. But if you see where someone's character is being defamed, or someone is complaining that their neighbor is a nuisance, or a father left his child and they're sick or something, negligence, anything of that sort is tort law. Or because persons cannot go and get the accused, or what, I don't want to use accused, that means the defendant arrested, sorry. Rather, they can only get compensation. If you see something speaking to an agreement, offer, and acceptance, you will know that it is contract law. But you will learn contract and tort next year in Unit 2 and real property. Functional. This speaks to substantive and procedural. Now, it refers to law or laws that define, describe, regulate, and create legal rights and obligations. It consists of statutory rules passed by the legislature, and that is someone is talking. That is the arm of government. That there are three arms of government: the legislative, the executive, and the judiciary. And the legislative or the legislature speaks to the arm that makes laws. So this is usually the lower and the upper house. These statutory rules, as I said here, govern how people behave and how they act. And these rules define crimes and their punishment. They also define our rights and responsibilities as citizens, and citizens must know what they can and cannot do. I have that as legal certainty. Well, I don't have it as legal certainty. That is the topic, sorry. And you will learn about it further, or if you focus on constitutional law, or if you focus on, or when you do constitutional law in university, that you cannot charge persons or arrest persons and punish them if they don't know what is wrong and what is not wrong. And therefore, law must be classified as functional because it must function as a way to guarantee citizens their rights and let them know that they're being protected. So while we have the subject matters, there are many other things or functions of law, but we don't want to get them mixed up, which is why you have to have the functional separate as a whole topic, separate from subject matter. Now there are two parts of functional, and you'd have seen that on your broad topic release, that is substantive and procedural. Now substantive is the way it's a two-phase approach. So one part is basically like identifying, and then the other part is speaking about what will happen. Substantive is like establishing, is a part of law that establishes the rights. So when the rights are made by the government and it speak or case law or any other area of law that speaks, that identifies that this is an issue, and it gives somewhat of a presumption. So it doesn't give the final answer, the final thing about what is happening, what will happen, but it gives sort of a presumption. So, you know, like how we always talk about there's a presumption that someone is innocent until proven guilty. Yes, so substantive give the presumption that, all right, the person comes to you, they said they killed someone or they shot someone. Substantive area of law will say, well, that might, well, not that might, that will be criminal law. So one we identify will be criminal law. So functional helps you to identify the subject area as well. So this is where they coincide. So you identify that it will be criminal law. You also now identify that you will have to go to this specific court. You can't carry a matter of, if it's a tort issue, you know you're not going to go to the gun court. If it's if it's another criminal offense not involving a gun, you won't go to the gun court. So it helps you to identify what is the area, where will we go, what will happen from there, what might the DPP bring forward, and also what defenses you might have. So it helps you to identify all of that. And if it is a civil matter, as I have here, it allows you to identify what rights have been breached and what remedies might apply. For the procedural, on the other hand, this does not really identify. It speaks to what happens after the substantive. So after you have identified and after we go to court, what will happen? So basically the procedural is the procedure that the court follows. It's the rules that the court, or in other words, the rules that govern the judiciary. So it's not only the courts, it governs well, in our case in Jamaica, the JCF and other members of the judiciary. So these rules govern, as I have here, how the court may come to a decision and the remedies that the court might provide in a civil matter, or if it's a criminal matter, it deals with how the person will be sentenced. See, as I have here, or I note here, sorry, Civil Procedure Acts, or of the civil, or sorry, I had a mix up there, but really it's a Civil Procedure Acts, or sorry, it should be Civil Procedure Acts or Civil Procedure Rules of Caribbean countries. So you can basically just Google that and they will come up. Probably you will see a Ministry of Justice site and it will take you there to see the Civil Procedure Rules of Caribbean countries. It speaks to the rules that the Supreme Court must follow when dealing with issues of a civil nature, or tort, or contract, or anything of that sort. So the remedies that they can provide, and so forth and so on. I also made some suggestions of some cases here, so you can check these out. R and Crown Courts at Manchester, Clingham and Kensington, and Chelsea Royal London Borough Council. And for criminal procedures, you can see sentencing legislation, or you can see legislation that governs the constabulary force and how they should act in arresting persons and taking statements and so forth and so on. And you can also see the constitution that governs the particular jurisdiction that you are studying, because in the constitutions, there are things that talk about, what the Supreme Court can do and what cases what can they hear. So for example, when we get to modules, we talk about judicial review. Yes, so only the Supreme Court or the High Court in the country can really hear matters relating to that. So you see all of that in the Constitution. So you can check the Constitution as a source. Criminal law. You will learn more about criminal law we will talk more, because you should have already learned it, about criminal law when we get to module 3. But it's a system that is concerned with punishing persons who have committed a crime, and it is between the person and the state. I will speak more about criminal law when we get there. It is also a part of functional. And there is civil law, or the Ramona-Germanic legal system, which is concerned with private relations, or private relations or the rights of individuals, and it provides a remedy if these rights have been breached. So with civil law, persons won't be arrested, they will be compensated, and that is a part of functional as well. We get to conceptual, or it's also known as law by concept, and it deals with private and public law. Law can be classified by concept, and this can be divided into two areas, which we would have already mentioned. Earlier, I have here a question for you. Earlier, we identified criminal and civil law, and I would have spoken about it's between individuals and who. So can you tell me which is public and which is private? All right, so before I ask that question, let me rephrase. Or let me explain. So private law is a private issue. It's only relating to individuals between themselves. So Jack and Mark both go to court because, well, there's a law between, there's a wall, between the 2 yards, but for some reason, Jack's water is always going over Mark's yard. So they will go to court with a private issue. Someone in the chat gave away the answer. So basically, yes. All right, thank you. Can I call you by your last name, Duncan? Because I can't really pronounce your first name, so sorry. All right, so basically, private matters, as you said, are between individuals, and then public law is between individuals and the state. So criminal law would have been a public law matter because it's between an individual and the state, usually being represented by the DPP, while civil law would have been a private law matter because it is usually between an individual and another individual. All right, so private laws I have here to make the explanation a little bit more formal than what I would have given a while ago. Private law is a form of civil law which refers to legal matters which exist between two or more individuals, or it can be between individuals and other. It can be between individuals and other individuals, or individuals and an organization or a company. So, for example, you work with a supermarket, or you work with a telecommunications company and they breach the contract, you can seek civil redress in court. So some areas are under private law, which I would have already spoken about, and you will do them in Unit 2, contract towards real property, but it includes several other areas. So family law, which deals with divorce, man and woman, or any rights regarding that. It deals with children, when children come into play. You have environmental law, you have entertainment law, you have insurance law, you have many other areas. So public law refers to legal matters between an individual or individuals and the state. Thus, as I explained before, criminal law falls under public law. And why? Because I have an example here. If A kills B, his murder trial, it would not be safe to have his murder trial between himself and the family of B, because how would he really be charged? So because of that form of confusion, conceptual have come into play to ensure that, okay, the concept of law, is that when someone does something wrong, like murder or robbery, they go face to face with the state, and it is usually represented by the director of prosecutions, public prosecutions, who for Jamaica, you guys know is Paula Llewellyn, sorry. So they go face to face with the DPP or representatives from the DPP's office, and the burden of proof is on the DPP to prove that this person committed a crime beyond a reasonable doubt. Someone was saying something? Yes, so it's now on the DPP to prove that a person has done something wrong, and they prove it beyond a reasonable doubt, so that we don't actually have innocent people going to prison. But I have something here that I want you guys to not have this notion or this thought that only criminal law comes under public law. There are other subject areas which to you might have seemed to be civil, but they're not civil. They are private law, but they're not, or well, sorry, they're civil matters. Let me not get confused. So there are other areas to you that are civil, and because they're civil, you might think they come under private law. So I want to make a note of that, that not all civil matters, most civil matters come under private law, but not all civil matters come under private law. That is because, as we would have noted before, private matters are between individuals and another individual, or individuals and an organization. However, public law is between an individual and the state. And so when you think of the civil matter relating to an individual and constitutional matters, then, or the constitutional breaches, then they will go against the state. And once they're going against the state, it is a public matter. So constitutional law is public law. It's civil, yes, but it's public law and not private. While the DPP represents the state in public matters, the Attorney General, on the other hand, represents in criminal matters, as I say, yes. The Attorney General, on the other hand, represents the state in public matters, regarding constitutional law and administrative law. Administrative law, on the other hand, and I don't want you to get it confused, but you don't really need to know about it now, but to not get you confused, it's like constitutional law, but it's not really constitutional law. Administrative law is an area of public law, and it usually speaks to legal matters between individuals and government ministers or public bodies that are usually run by the government. So, for example, if there's an issue between the Minister of Gender and someone else, then it will be an administrative matter. It will not be a constitutional matter. But both areas form under public law, and they're pretty close. All right, so there will be a past paper question after this, which is why I have this tip about how to write an essay. So, important information, the question and classification will be an essay. It more than likely will be an essay. Maybe they can find some creative way to put in a problem question, but as far as I'm concerned, and as far as I will see, I think it will be an essay because it's just more convenient to put this question in an essay format. So if it is an essay, you cannot get straight to the point. You cannot talk about classifying something that you don't know about. Therefore, I have here that you must start your essay by defining law. Other important tips, your essay must include the usual introduction, body paragraphs, and conclusion. The introduction, as I have, must have the general topic, which is law. What is law? But you must eventually steer towards classification and must end with asking the question, or sorry, with introducing the specific section, within the question. The body paragraphs must include different areas connected to the specific section, which is classification. So your body paragraphs now must talk about the functional, the subject matter, and conceptual. It must also have cases and texts and any other sources that you have identified. I said this to Unit 2 students, and I will say it to you again. When answering a problem question or answering an essay, this area is called law. Now, do you know that a classification essay can be a regular English essay? Yes, it can be a regular English essay, because if I just go into classification, I don't use any cases, I don't use any sources or whatever. I'm just using it as a topic, as an inspiration. I can write something about science in my English essay. I can write something about law in my English essay. It does not make it a legal essay. No, you are answering a legal question in an area called law, which means in your body paragraph, it cannot be high and dry and filled with everything about classification, but nothing about law. And when I talk about law, I don't talk about the areas of law. I talk about statutes or cases or any other source that you can identify, because it's a legal essay and it must have something that is legal for you to get the marks. Then I have the conclusion, which is wrapping up everything that you would have had in your essay, and it's just a regular conclusion. So how would I write the essay? I would first define law and the concept of law. I would use the development step, which is according to the different theories, but I will wrap up with the definition given by Bell and Kwan, which I think you have in your study guide. I also place a note here that I don't want you guys to think the question is on, because you're starting with the theories, don't think about anything about law and morality and religion. So don't go off on a rant about law and morality and all that. No, you're talking about classification. So please just give a quick introduction and hurry and get to classification. So secondly, still in the intro, I will explain the general term law. I will explain that the general term law can be classified into different sections, and I will give a reason why it is placed into these sections, because this is what we're talking about, classification. After I've given the reason, I would identify the sections and their subsections. So I would go into conceptual now, I'll go into functional, I'll go into subject matter, and then the examples that we're given on your syllabus, like for example, subject matter have to work contract. Yes, I will put that there. And that all of that would be your introduction. Then head into your body paragraphs, and you should again identify these sections, conceptual, functional, subject matter, and speak extensively on them using cases and any other information that you might have. So the past paper questions. The first part, as I said, usually your questions come like that, and that should be B, where Mr. Cheapsteak is. Sorry about that. So the first part says state the differences between public and private law. So guys, anyone wants to tackle that? It's 6 marks, and you're literally just listing them and explaining them. I think it's the easiest 6 marks you'll ever get in your life, because it says state, so you don't have to go extensive.
Well, just a brief overview of what private law and public law is. Well, public law would look at the relationships between the individuals or the institutions of the state, rather than the relationships with the state. And then public law would directly look at the relationship with the state and individuals. So it would look at the government and the subject, and then also the relationship between the individuals coming directly from the law. And then to explain the differences, I would talk about examples of each, such as in public law, it's characterized by criminal law, constitutional law. You spoke about administrative and also, I believe, tax law. And then private law, it would look at matters under tort, contract, and other stuff. Can't readily remember right now, but yeah, that would be like the organizational strategy going in for the question.
All right, so that is correct. So that is 4 marks. Because you identified 2 differences. The last one that I would suggest to you, and I hope you guys were taking notes of what he was saying a while ago. Give me a second. I don't know why my screen has. All right, Jade, I saw that your hand was raised.
Yes, good morning. Another example could be as it relates to constitutional law, it is concerned with the workings of the British Constitution, and it covers matters as it pertains to the law, which like governs the citizens of a country, like for example, the fundamental rights. And then civil law now, or private law, sorry, are dispute between private individuals and are governed by the statutes. For example, the Road Traffic Act.
Okay, thank you very much, Jada. So that is correct as well. And so you guys can make a note of that. And the last thing I will suggest is also the fact that under public law, there are two forms of remedies. The remedy of having a person arrested or uncharged, convicted, sentenced because they faltered in criminal law, or the remedy redress, being afforded to them under constitutional law and under administrative law. But under public law, under private law, the only thing that is available is remedies such as damages and so forth and so on. So again, just to read over, because I know I made some little mishaps a while ago, you might get confused. Under public law, there are two ways where a person can be relieved, if that's the word. One, knowing that the person who did something, a criminal thing or a criminal offense, against you and your family will be charged and convicted and sentenced, or the fact that it's a constitutional matter and you receive redress. While under private law, the only thing that is available is remedies such as redress or damages and so forth and so on, because a person can't be arrested under private law. So I don't think I really have to go over everything that was said, but those are the basic things, or the basic differences between public law and private law. So that's 4 things, and you can pick any 3 to explain this question, and that's 6 marks, 2 for each. So 2 for identifying and explaining. Mr. Cheapsteak bought a pair of shoes from the Low Value Bargain Center. After wearing the shoes for 2 weeks, the sole of one of them dropped off. He returned the shoes to the store, but the manager refused to exchange them or give him a refund. In anger, Mr. Cheapsteak slapped the store manager, who fell to the ground and broke his hand. The store manager reported the matter to the police, who charged Mr. Cheapsteak. Mr. Cheapsteak retained you as his attorney. Explain how the knowledge of classification of the law will be an advantage to you in representing Mr. Cheapsteak. So I'll give you an example of how I'll answer this question. I didn't write it because really and truly, I don't think I really need to write. It was an essay. So I'll just give you guys some pointers and you can make a note of that. So I do hope you have your pen and paper. So I will start as I would have suggested before, how I would write an essay. Okay, all right. So Javon is asking that you guys get 30 seconds to reread. So I will give you that time so you can read over the question. So it's part B of the question, starting at Mr. Cheapsteak. Okay, guys. So how I would answer the question, as I said before when we were talking about how to write an essay, I would start by giving the definition of law, and then I would move into the fact that in order for us to be confused. So I'll give the reason for why we have classifications of laws. For the law to be presented in a simpler format and for persons to be compensated under the correct areas, it is necessary for us to classify the law. How is the law classified? You would define, or you would explain that the law is classified into 3 areas: subject matter, functional, and conceptual. You would then explain that under subject matter, it identifies exactly what area of law you are dealing with. And so you know, so you can go into the fact that when you go under subject matter, you identify, for example, contract law, criminal law, tort law, and you explain that functional, on the other hand, has 2 parts, substantive and procedural. You explain that under substantive, it also identifies the area, but not only identifies the area, it identifies what the presumption, what might happen under the area. And then you go and then procedurally talk about what the court or the rules that the court follows. And you go into conceptual, which you speak about public and private law. So again, you identify what is law, you speak to the fact that law must be classified and reason why law must be classified so that we don't get confused, so that lawyers and judges and clients can all know what area to tackle. And you go into the different sections, because your syllabus would have identified that you must know reasons. So if you see a question like this, you must identify the reasons. Then you go into your body paragraph, and I would suggest that your body paragraph, you explain each area. And in explaining each area, you must then tie it in with the question. So when we go to subject matter, how will my knowledge of classification be to Mr. Chesapeake's advantage under subject matter? Because it helps me to identify what is going on here. It's a whole case. It's mixed up. It's a lot of things going on. He's having a problem with a man not giving the man his refund. And then there is the whole thing about breaking the man's hand and being charged and everything. And you're so confused right now, you don't know what to do. So, but he retains you as his attorney because he has been charged by the police. Now, as his attorney, your knowledge of classification of law gives you the advantage of understanding that the matter that you're addressing is criminal law. Because you're addressing the fact that the police charged him. You're not addressing the fact that he had an issue with the man. So it wouldn't be tort, it would be criminal law. Now, if you didn't have knowledge on classification, you would probably go to court arguing tort. So you need to make a note of that. You probably go to court arguing something else. So your knowledge of the classification of the law allows you to know firsthand that the matter at hand is tort law, so that you as a lawyer don't get confused, and so that the client himself don't get confused and the police don't get confused. Secondly, you would talk about functional law. Your knowledge of classification allows you to know that there are 2 parts under functional: substantive and procedural. Now it allows you to identify, again, 1, that is criminal law, and 2, it allows you to identify the fact that he possibly will be charged for probably wounding with intent or some other offenses against the person. So maybe your knowledge of criminal law will also help you here. You can make a note of it. Don't talk about it extensively because the question is not on criminal law, but because it's an essay and you've always been told that you should assume that your markers don't know anything about the law, you want to let them know that, okay, this still has some criminal matter in there. So I know a little bit about criminal law, so I will include it here. And then you want to talk about the procedural. As a lawyer, you now know that he may possibly be charged for this, but what specific area and what might the judge do to him? Will they charge him? Will they convict him based on the rules of the court? And then how will he be sentenced? because again, I sent you to look at the Sentencing Act or to look at the Constitution and the rules of sentencing and how can he be treated in the police here, how can they question him and all of that. So you can look at all of that and explain it. And the reason why you're able to identify this is because of your knowledge of classification. So it all ties back in with the question. And then the last part, you would talk about conceptual. And your knowledge of conceptual allows you to realize that this is a public law matter because it will not be between him and another individual. Because again, you would have already identified from your very first paragraph that you're dealing with criminal law. Your knowledge of classification now allows you to know that criminal law is a public law matter, and your knowledge of classification allows you to know that, and what you would have already explained in part A, your knowledge of classification and about public law in general allows you to know that it's between him and the state, and that the remedies available is not necessarily to him or to the claimant, but just that for the society in general to be relieved, he may be convicted and charged. Well, he's already charged, so he may be convicted and sentenced rather. And then you conclude. So that is how I would answer the question. All right, so Anika is asking if the session, since the session is being recorded, will it be provided for review in the WhatsApp group? The session will be posted to YouTube, so you can watch it over on YouTube once it's posted. I'm not sure if it's live now on YouTube, but I know for a fact that it will be posted on YouTube. So after this session is over, you can watch it on YouTube. All right, so it's just New Jamaica Foundation. I think that's the name of the YouTube channel. So you can just, hold on. Give me 1 second. So I placed the name of the YouTube channel in the group. Jada is asking, can I apply the IRAP method to a problem statement? Yes, but you cannot apply the IRAP method here because this says to explain. Had it been a case where it said to advise Mr. Chief Say, then it would have been a problem question and then you would have applied the IRAP method. All right, guys, so I'm going to give you a 10-minute break. All right, so I'm not sure if you heard me a while ago, so I'm going to give you a 10-minute break, sorry, and we will come back and we'll head into module 2. But if you have any questions, you can type in the chat or you can talk to me while I'm here. But for the others, if you want to take a break, you can take a break. So we return at 11:14. All right, guys, I'm back. All right, let me know if you're seeing my screen. Can just type in the chat. All right, good. So, all right, let me get the slideshow up. All right, so this is module 2, principles of public law. So what is public law? We would have discussed it before. We would have discussed it earlier, and we would have said that public law covers legal matters between individuals and the state. It can be with criminal matters between the DPP and against the DPP, well, the DPP representing the state, sorry, and it's usually between an individual and the state. So it's usually the DPP representing the state, and you have public law, which covers constitutional matters, which you usually have between an individual of the state, but the DPP don't represent this case. It's usually the AG, which represents the government here, and same with administrative law, but again, the DPP, well, don't represent the state here. It's the Attorney General. So always remember, once it's a criminal matter, is the Director of Public Prosecutions, which makes sense, public prosecutions, but once it is an administrative or constitutional matter, it will be the Attorney General. So the broad topic, CXC indicated that you should focus on the fundamental rights and freedoms within Caribbean constitutions. And the syllabus states that students should describe the fundamental rights under the Constitution and should discuss what happens when one's fundamental rights are breached. So, and it indicated here that you should focus on judicial review. So first, we'll talk about what are fundamental rights. And I have a quote here from the great Simeon McIntosh, which we call him the Constitution, the Caribbean Constitution guru. And he said here, a set of basic human rights, or well, fundamental rights and freedoms are a set of basic human rights which constrain the exercise of legitimate governmental power by someone's mic is open. Again, fundamental rights and freedoms are a set of basic human rights which constrain the exercise of legitimate governmental powers by agencies of the state and are legally enforceable in favor of the citizen through the practice of judicial review by an independent judiciary. So the basics, so to break it down, fundamental rights and freedoms, you will get like about a dozen human rights and or more, and it speaks to the fact that the government cannot, no matter what laws they pass, they cannot override these human rights. And if they pass a law that overrides or contravenes these human rights, then it can be reviewed by the court, usually the Supreme Court, but we'll get further into that. So rights and their restriction on governmental powers seen in section 13 of section 13, subsection 2B of the Jamaica's Constitution, which says that Parliament shall pass no law and no organ of the state shall take any action which abrogates, abridges, or infringes those rights. Important things to note. Fundamental rights and freedoms are normally derived from international treaties, 1, 2, including in all Caribbean constitutions, and 3, afforded to all citizens. International laws connection. So as you would have seen from Simeon's note, is that fundamental rights and freedoms are basic human rights. These human rights, you guys must note that they are recognized universally. And they're afforded to us simply because we're humans. A lot of these rights came after World War I and especially after World War II. After World War II, the United Nations General Assembly would have come up with the United Nations Declaration on Human Rights. And that gives a set of basic human rights that must be afforded to every human. And it was in an attempt, of course, because you know that we had World War II and a lot of persons died and a lot of persons were protected. So United Nations Declaration on Human Rights is one of those documents that is trying to not to see that, okay, persons are always protected and that we don't have another issue like this again. Apart from that, we have the ICCPR, which is the International Covenant on Civil and Political Rights. We have the International Covenant on Economic, Social, and Cultural Rights, which is the ICSCR. And we have the Convention on the Rights of the Child. And there are lots of other things. We have conventions for women and for persons with disability and all that. It must be noted, however, as I put here, that while the UDHR is there, and persons and countries are expected to follow it, especially if you have ratified it or you have ratified any other international convention or treaty. The UDHR especially and some of the and the other conventions are not binding, but the UDHR especially, because it says declaration. Once that declaration, it's not really law per se. It's not binding. You don't have to follow it, but it is expected that countries will follow it, and many Caribbean countries have followed it and have followed other conventions, because you will realize that when you see the UDHR, these rights are afforded under the Constitution. Let me pull up the UDHR and show you. Give me a second. Someone. Okay. All right. Give me 1 second. All right, so here is the UDHR. All right, so that's the preamble. But let's start with some of the articles. All human beings are born free and equal in dignity and rights. They are endowed with reason and conscience and should act towards one another in spirit and brotherhood. Everyone is entitled to all rights and freedoms set forth in this declaration without distinction of any kind, such as race, color, sex, language. I'm sure that sounds like the opening statement of most of the Caribbean fundamental rights and freedom sections. Everyone has the right to life, liberty, security of person. No one shall be held in slavery or servitude. No one shall be subjected to torture, to cruel or inhuman or degrading treatment. Everyone has the right to recognition everywhere as a person before the law. And it goes on. No one shall be subjected to arbitrary arrest, detention, or exile. So you see what I said when what I mean, sorry, when I said that most Caribbean countries follow this. And I can also show you the International Covenant on Civil and Political Rights. All right, so part 3, which deals with the fact, again, every human has the right to life, and it goes further to explaining it because the ICCPR protects especially those rights when it comes on to like the death penalty and stuff. and no one should be subjected to torture, to cruel or inhuman or degrading treatment, and it goes on. And International Covenant on Economic and Social Rights now deals with second generation rights, which we see in some of our constitutions. Article 3 again. All right, so the state parties to the present covenant recognizes the right to work, goes further into the right to work, the right of everyone to social security, including social insurance, to have an adequate standard of living, to health, there's also education, and it continues. I won't do the one about the rights of the child, particularly because, well, I'm guessing that you guys get the gist of what's happening. So although these are not binding, you will realize that most Caribbean countries have ratified them, and because they have ratified them, they included these international rights into their constitutions. So now you see international laws connection. Now we get to the meat of the matter. They're included in all Caribbean constitutions. Fundamental rights and freedoms can be found in all Caribbean constitutions, but the only thing is that you might find them under different headings or under different titles. So, but we know them as the Bill of Rights. We know we're talking about the Bill of Rights because all constitutions are the Bill of Rights. However, many constitutions, if not all, have been amended to have a different name for the Bill of Rights. But we still understand that when we talk about fundamental rights and freedoms, we're talking about the Bill of, if we're going to talk about the constitutions collectively, we're talking about the Bill of Rights, although they have amended and all of them have a different name now. And we'll go into some of those names. But the structure of Caribbean constitutions, or the structure of the Bill of Rights or fundamental rights and freedoms, you have the conventional or the neo-Nigerian model. Now, this model has 5 parts. It usually has an opening section, which is what I would have explained before, the whereas, or, everyone under this constitution is afforded the right, these rights depend, regardless of their sex or race or anything of the sort. Then you have, after that section, you have about a dozen detailed rights or more, like the right to life and all of that, right to our freedom of expression, etc. And then you have the redress clause. You're not seeing my screen?
Oh, we are.
Oh, sorry. Give me a second. Are you seeing it now?
Yes, we're seeing it now.
Okay, all right. So it's basically a list of the things that I was talking about a short while ago. So the opening, so you have the opening section, about a dozen detailed rights. Then you have the redress clause, which usually speaks to if someone claims that any of these rights that are at number 2 have been breached, they can get redress for it. You have savings law clauses, which speaks to which are usually limitation on these rights. And then you have provisions for emergencies. But for the purposes of CAPE, I don't see anything about provisions for emergencies. So we'll just look at the first 4, which is the opening section, the detailed rights, redress clause, and savings law clauses. All right, so, and later in this presentation, we will look closely at the differences between the different Caribbean constitutions and the different Bill of Rights, and then we will speak about general limitations on rights. So while the structure or the conventional model speaks about the savings or clauses, we'll also look at the general limitation on rights. So Caribbean constitutions, where can I find the fundamental rights and freedoms, or the names? What are the names? What are the headings that they appear under? Since, as I said, they don't usually use Bill of Rights anymore. Everyone has a different name now, and everyone has a different location. So for the Caribbean constitutions, for Jamaica, the Charter of Fundamental Rights and Freedoms is in Chapter 3. For Barbados, it's also in Chapter 3, but it's not called the Charter. It's called Protection of the Fundamental Rights and Freedoms of the Individual. And for Trinidad, you can see Chapter 1, and it is called the Recognition of the Fundamental Rights and Freedoms. And you go specifically to Part 1 of Chapter 1, which speaks about the rights enshrined. For Guyana, it's Chapter 3 just the same, but it's Section 40. And it's called Fundamental Rights and Freedoms of Individuals. For Grenada, it's Chapter 1, Protection of Fundamental Rights and Freedoms. And for Belize, it's Part 2, and it's named Protection of Fundamental Rights and Freedoms. So Grenada and Belize have the same name, while Guyana and Barbados have the same name. All right, so the opening section. All right, so when we speak to the conventional module, the main things that we look at is the first two parts, one being the opening section and the other part being the detail section. And this is in every constitution. So for Jamaica, Chapter 3, Charter of Fundamental Rights and Freedoms, Section 13(1)(a) is the opening section. And it states, whereas, all right, this is incorrect, but it should be, whereas the state has an obligation to promote universal respect for and observance of human rights and freedoms. B, all persons in Jamaica are entitled to preserve themselves and future generations the fundamental rights to which they are entitled by virtue of their inherent dignity as persons and citizens of a free and democratic society, and all persons are under a responsibility to respect and uphold the rights of others recognized in this chapter. I have here for Barbados, you can see Section 11, and Grenada, you can see Chapter 1, Section 1. I also wanted to note that Trinidad and Tobago have a different wording in that it doesn't start with whereas like Barbados and Grenada and Jamaica, Belize and Antigua. But at the end of the day, it's the same thing, although it's worded different. So while it's worded different, I don't think it's something to be crazy over, because at the end of the day, all this opening section do for every single one of these Caribbean countries is to give a general guarantee of rights. Now we get into the meat of the matter by describing the actual rights. So Section 13(3) of the Jamaican Constitution gives a detailed subsection, gives a detailed rights, give the detailed rights and freedoms, sorry. So you have A, which is the right to life, liberty, and security of person. Describing that, it means except. Someone is saying something? All right, so describing that now, it speaks to the fact that no person should be like, for example, falsely imprisoned or, falsely imprisoned or locked up or anything when they haven't done anything wrong. So you shouldn't be deprived of your right to life or liberty. So you shouldn't be executed or put on death row or locked up or anything of the sort if you did nothing wrong. And the only exception is where the person is being sentenced by the court. And I won't go too far into that, but you know that if the person is actually, if they did something wrong and they're thrown into prison or sentenced to a prison term, still have some form of rights in that they cannot be tortured or anything that is inconsistent with their human rights while they're in prison. Which is why when we looked at the case of Prata Morgan in I think it's still under this module, when you look at the case such as Prata Morgan, there was a problem because they were, or well, let me not use that case. There's another case, I think it's a Trinidadian case, where the man was locked up, and while he was locked up, he was being flogged. So although he was deprived of his right to liberty, he was not to be deprived of his right to not be tortured. So you have a right to life and liberty, except if you are convicted of a crime, but while you are convicted of a crime and sentenced, you should not be subjected to torture or any other thing that is against your other human rights. We have a right to freedom of expression, meaning that we can say what we want or we can express ourselves, but we have to be careful that because we as citizens, although we are afforded these rights under the Constitution, you would have seen that the opening section would have said we have a right to respect the rights of others. So you have a right to freedom of expression, but if your freedom of expression is going to defame someone's character or, you know, cause some other havoc to another citizen, then that person can take a civil matter against you. We have the right to freedom of peaceful assembly and association. This is not a strike. It's just freedom to assemble. We can have functions, we can do what we want, but a strike is not necessarily legal, so I won't get into that. We have the right to freedom. I would have skipped out some of them. Because it's a long list, you can check the Constitution for it. I think the Constitution was sent in the group, but I'll just go through a few. There's a right to freedom of movement. There's a right to equality before the law. There's a right to equitable and humane treatment by public authorities in the exercise of any function. And when we speak about this, most times we look at the police. All right, so Javon is asking if these documents will be shared. Yes, I'll send them in the group. The right to equitable and humane treatment by any public authority in the exercise of any function. The right to freedom from discrimination on the ground of being male or female, 1, and 2, race, place of origin, social class, color, religion, or political opinions. Now, you realize Jamaica did not put this in the opening statement, but it placed it in the detail rights, while other countries like Trinidad have placed it in the opening section. All right, so you have the right to enjoy a healthy and productive environment, and we'll get to that further when we get to the differences between constitutions, and I'll speak to why it's a difference later. You have the right to protection from torture or inhuman and degrading punishment, which I would have spoken about when I was speaking about the right to life. You have the right to due process, and you have the right to freedom of religion. Differences between Caribbean constitutions, fundamental rights and freedoms. Jamaica, well, as I would have said the names, Jamaica have Charter of Fundamental Rights and Freedoms. Trinidad have the recognition of fundamental rights and freedoms. Guyana have fundamental rights and freedoms of the individual. But Barbados, Grenada, and Belize have protection of the fundamental rights and freedoms. Another difference, location. For Jamaica, Barbados, and Guyana, you can find it at the Fundamental Rights and Freedoms at Chapter 3. For Trinidad and Tobago and Grenada, you can find it at Chapter 1. For Belize, it's at Part 2. And in the specific areas, when we get to the detailed rights, for Jamaica, it's Section 13.3. Barbados is Section 11. Trinidad and Tobago, it's Part 1, Section 4. Guyana is Section 40. Grenada is Section 1. And Belize is Section 3. Other differences. the rights and the actual detailed rights and freedoms, we have differences there. So, for example, for Jamaica at section 13L, I told you that we'll get to this. The right to enjoy a healthy and productive environment free from the threat of injury or damage from environmental abuse and degradation of ecological heritage. Now, Guyana also have this right, but the bulk of Caribbean countries, to include Barbados, Belize, Trinidad and Tobago, Grenada, they do not have any rights regarding citizens and the environment. So, and then one thing I want you to know is it's fairly new. It's a second generation, right? And you remember when I went to Google and I showed you the ICCESCR, which is the International Covenant on Economic, Social, and Cultural Rights. Those rights are fairly new, and you will find that many Caribbean countries, and they're mainly Eastern. So that's one thing I want you to know. So you see, when we talk about the International Covenant on Political Rights, on civil and political rights, those are first generation rights. And you'll find that, like the right to life and so forth and so on, and you'll find that most countries in the Western world will have them, they will log on to them, yeah. But then when, especially because those came right after the whole World War thing and so forth and so on. But then you'll have the second generation rights, which are mainly Eastern, and you don't find a lot of Caribbean countries having them, but I would say yet. Because, you know, the constitutions are amended from time to time, so maybe they will have them, or maybe they will include them in legislation, we don't know. Other differences are other rights that only a few Caribbean countries have. Right to privacy, only Jamaica, Belize, and Trinidad have that right. Right to family life, only Jamaica, Belize, and Trinidad again. Rights for workers, Jamaica don't have this, only Guyana and Belize have it. And if you remember when I looked at the ICESCR, you will realize that that's one of the first rights that's there, the right to work. Right to education, again, it's our ICESCR law, sorry. And only Jamaica and Guyana has this right in its domestic law or in its constitution. You have rights of the child, and although many countries have ratified the Convention on the Rights of a Child, from all the countries I've been talking about, only Jamaica and Guyana have it. Rights against discrimination, sex and gender, Jamaica and Guyana have this. But when it comes to rights against discrimination based on disability, only Guyana have included this right. So one of the key differences, and I want you to make a note of this, one of the key differences between Caribbean constitutions, fundamental rights and freedoms is that most countries have not yet included the rights afforded under the ICSCR. And again, ICSCR, you can write this, I'll talk a little bit slow so you can write it, is the International Covenant on economic, social, and cultural rights. So it's the International Covenant on Economic, Social, and Cultural Rights. Many countries have not included this in their fundamental rights and freedoms. And that is the main difference between the detailed rights of our constitutions. You will find that only Jamaica and Guyana have most of them, and sometimes you will see Trinidad and Belize pop up, but mainly Jamaica and Guyana. And then another key difference, which is particularly sad, and you might have to make a note of this as well, is that many countries have not included anti-discrimination rights and have not incorporated international human rights norms. So it's a key difference, and it's sad because the world is changing, and you'll expect that given that there are no international provisions that were aligning with the change in the world, we would think that our domestic law or constitutions would have also followed here, but unfortunately that is not the case. All right, so another set of things or key differences between Caribbean constitutions is the opening section saga, which we'll get into, recognition of rights of the ICSCR, but we've already gone through that, so we won't go through it again, and then savings law clauses. The opening section saga, most countries with the conventional module have an opening section, which provides a general guarantee of rights. But while countries such as Jamaica, Barbados, Grenada, Antigua, and Belize have the whereas the state must promote universal respect for and observe human rights and freedoms, there are countries like Trinidad and Guyana who have a slightly different opening section. So for Trinidad, it states that it is hereby recognized and declared that in Trinidad and Tobago there have existed and shall continue to exist without discrimination because of race, origin, color, religion, or sex, the following fundamental human rights and freedoms. While Guyana have, every person in Guyana is entitled to the basic right to a happy and creative, productive life, freedom from hunger, disease, ignorance, and want, and the right includes, and I made a note here that it includes the fundamental rights and freedoms, and after that, you will have that detail that you see with Trinidad about race, origin, color, religion. I didn't put it there, I put the ellipses, but it's the same thing that is there for Guyana, which is why I didn't put it back. So it is slightly different, but it's kind of still giving a guarantee of rights. That is not really the opening section saga. The opening section saga is more concerned with whether the section itself is an enacting provision, which is whether if I can go to court and say my fundamental rights have been breached, but the only fundamental rights that I'm talking about are those that is the general rights that are guaranteed in the opening section. Now, many cases before this case that I'm going to talk about would have suggested that it only guaranteed mere rights or a general rights, or it's too wide, and therefore it cannot really be binding, or it cannot really be enacting. One of the problems with that for many persons, however, who deal with constitutional law, is that the opening section guarantees mostly second generation rights, such as the economic, social, and cultural rights. And if it's not enacting, then a lot of persons would not have their right to work or education and all of that governed. So Nervous and R is one of those cases which speaks to the fact that the opening section is actually enacting. And there's Boyce and R, but I will not talk about Boyce and R because it was someone sent a document in the group and it has Boyce and R, and I think it has a very good explanation. So I would say that you guys can check that document. Now, Nervous and R, earlier cases dismissed the contention, as I explained before, that it was an enacting, that the opening section was an enacting provision, and this is because it had whereas. And you know, sometimes when you hear whereas, you're thinking, oh, whereas it's this or that, either. So it's a little confusing. So they're saying because it has whereas, it's not an enacting provision. And then they said that because the redress clause did not list it as a provision giving rights to redress, it's not an enacted provision. They're saying, well, if you can't get redress for it, then it's not enacted. However, in Nervous, it was held that the word whereas could easily have been construed to mean it is hereby recognized and declared that, or even simply in light of the fact that. These are meanings normally attributed to whereas. It was further held that the meaning of the word should at least reflect its context. And the context in this case would include the historical statement in the preamble of the Constitution of Barbados that the rights now declared were being enjoyed since 1652. The Caribbean Court of Justice concluded that the word whereas should have been construed as intended to convey that the simple fact, and they can find no justification for attributing meaning which deprive the section of any binding effect. So in essence, to wrap up all of that, both the opening section and the detailed rights are now considered to be enacting provisions. Meaning, I can go to court and claim that a law has been passed that breaches my rights afforded either under the opening section or in the detailed rights. Now we'll get to limitation on rights. You have 4 good reason limitations, and you have general and special savings law clause. Now, what we mean by limitation is, for example, we all have our rights. The government passed a law that contravenes these rights, and we go to court. The government, the burden of proof is now on the government to say that, well, we did this, we limit these rights because we have a good reason to do so. Normally because it's in the public's interest. Or they can argue that there are some general or special savings law clause that is in the Constitution, which allows them to put a stop or to pass a law that is in contravention with your rights. We'll get further into them. So for good reason limits on rights is justified as being in place to protect the public interest and rights and freedoms of others. And the for good reason limitation clauses are usually in the Constitution. So this second one, reasonably required for a legitimate state interest and or reasonably justifiable in a democratic society. And this last one now is in our Constitution, in Jamaican's Constitution, which says demonstrably justifiable in a free and democratic society. So for Antigua and Barbuda, it's here, and that speaks to the second one, reasonably required, and you will get this slide. So I won't stay too long on that. But for Jamaica, it says section 13(2), sorry, subject to sections 18 and 49 and subsections 12 of this section, and I've highlighted it, and save only as may be demonstrably justified in a free and democratic society. This chapter A guarantees the rights and freedoms set out in the subsections, and B, Parliament shall pass no law and no organ of the state shall take any action which abrogates, abridges, or infringes those rights. So basically what he's saying is that Parliament cannot pass any law that goes against your rights, save only as may be demonstrably justified in a free and democratic society. So for the state to succeed on a claim like this, or to prove that the limitation is reasonable in a free and democratic society, they must prove that, one, the limitation was not too great on the citizens' right. That means when they give a limitation, it doesn't override your rights too much. So the citizen can still feel like they're living in a democratic society. They can still feel like they have their freedom, even though there's a limitation. It's not too great on your rights. And two, if they're going to argue that, oh, we had to pass a law that goes against our right, they must show that it is necessary to protect public order. I noted 2 cases that you can use here, Hector and the Attorney General. One of the things with this case is that the man had published, he was a journalist, and he had published something, and the law, the government had passed a law which says that you couldn't publish certain things for certain purposes. And because he had published that document, the government they had locked him up. He was arrested. So he went to court claiming under a constitutional matter, saying that, well, this law was against my rights. The government had argued that, well, it was for good, right? It was necessary for public order. But the court had struck it down, saying that the limitation was too great on the right, that right to freedom of expression, and that too, it was not necessary for public order. It would not, the law on restricting journalists was more about the government protecting their character. They don't want anyone to go out and write about them in a negative way, rather than it was for the public. So if it's about the government and their personal reasons, that is not in public order or has nothing to do with the public, so the court will not allow that law to be passed. They will review that law. And I have here that you can also view the NIDS case since it's current and it has to do with Jamaica, and we're moving forward with NIDS now. It's good to see what they have. Someone is talking? It's good to see what was the NIDS case about, and since as we're moving with NIDS now, what have the government gone back and correct about that law that will allow them to move with NIDS now? All right, so limitations and legal certainty. We would have spoken about legal certainty briefly in module 1. So I noted here that a justification for limitations on rights will not succeed if there was no legal certainty. And as I said, as we discussed when we spoke about classifications, the law must be legally certain. This means citizens must know what is wrong from what is right. And laws that limit persons' rights that are not legal certain the Supreme Court will review them. Why? Because citizens must know what is wrong and why it is wrong. And the law cannot be vague. It cannot be that everyone has a different opinion. The judge have a different opinion. The police believe this is it. The citizens believe that. No. There must be something across the board that the politicians, the judges, police, everybody, legislature, judiciary, executive, everybody can know that, and the citizen themselves can know that this is the law, and if they go against it, they will be charged. I had the case McEwan here, where the appellants, McEwan and the Attorney General. In this case, the appellants were convicted for cross-dressing in public for an improper purpose. Their human rights, such as freedom of expression, were violated. However, one of the issues was that there was no clear definition for improper purpose, and this was left up to the personal interpretation of the police. The Caribbean Court of Justice held that, firstly, by criminalizing only a purpose and a vague, undefined, and extremely broad one at that, the offense represents an unprecedented extension of criminal liability. So basically, the CCJ had a problem with this because the law was not legally certain and the word improper purpose was not certain, and so it was left up to the police to define it. Another legal certain issue that we'll find in the Caribbean is obia, and I'm careful treading that area because I know not many people are comfortable with that, but as you go in law, you will find many areas that you're not comfortable with. You find that you have to talk on obia and you have to talk on abortion, and we may not be comfortable with it, but we're doing the courses, so we'll have to explore them. So when you get to law and legal systems, if you continue with the law, you will see where you will deal with obia, you will speak on obia as one of those matters of legal certainty. Because I think in the Constitution, or in the obia Act, it speaks to obia being wrong if you use if you make certain noises and if you use certain items like salt and water and stuff like that and oil. And it's not legally certain because, for example, You may be a Christian and you may go to a regular Pentecostal church or to a regular church, and you may make some noise, sing, and you may use olive oil. Are we going to lock up the pastor that is using olive oil and say that he's working obia? That wouldn't seem to make any sense. Because when we think of obia, we think of someone who is at a remote area and they're using all sort of stuff and doing all sort of things, all sort of oils that we don't know about and stuff. But the law on obia does not refer to someone at a remote area using oils that nobody knows the name. It talks about people in general. So if you go to a room right now, or you go downtown, or you go somewhere right now and you are just singing some songs and you're using olive oil, you may be charged for practicing obia. We don't really charge people for it in Jamaica anymore, but that was the case and it's still there. Why is it still there? Why do we still have a law like that? So that's where legal certainty becomes an issue, where it's saying that if you're going to have a law on obia and obia is your problem, you must state clearly what is obia. We don't know what is obia because you say any oil. So using your olive oil to stop your foot might just be obia, or might just be considered obia, or the police can arrest you and say, well, in their view, you're using oil and olive oil is oil. So the next type of limitation that there is shutout clauses or savings law clauses. You have general savings law clauses. These clauses save laws. So I want you to make a note of that. General savings law clauses save laws that were in force before the Constitution came into force. And then special savings law clauses save punishments that were in existence before the Constitution, and lawful before the Constitution came into force. So what does this mean? General savings law clause save laws. So if the law is that you should not do anything using oil, a general savings law clause would have saved that law. And if the punishment for using the oil or doing anything of that sort was that you were supposed to be subjected to the death penalty, then the special savings law clause saves the death penalty, saves the punishment. Where you can find general savings law clause, it usually reads something like this. This Constitution is the supreme law of blank Caribbean country, and if any other law is inconsistent with this Constitution, that other law shall, to the extent of the inconsistency, be void. So basically, the law saves these laws, and these laws are allowed, they're legal, and any law that is passed or anything that we come and we say, oh, this is wrong, or it is wrong, these savings law clause will say, well, nope, the government can rely on them. You can find it in Belize Part 1, Section 2. You can find it in Grenada, Section 5.2. And it says, nothing contained or done under the authority of any law shall be held to be inconsistent or in contravention of this section, to the extent that the law in question authorizes the infliction of any description of punishment that was lawfully in Grenada immediately before the coming into operation of this Constitution. So basically it's saying whatever was here before, it can stay here. And even if the government passed a law and adds to this law and say, well, we were going to continue with this kind of punishment, it's not in contravention with the Constitution because there's a savings law clause within the Constitution. It's also in Barbados, Section 13. It's in Trinidad and Tobago, Section 2. It's in Guyana, Section 8 and Section 65.2. But I do want you to know that Jamaica does not have any shutout clauses, which is why originally when we were talking about differences with the fundamental rights and freedoms, I said that savings law clauses are a part of it because Jamaica does not have it. And more Caribbean countries' constitutions are being amended, and it's possible that the more they amend, most countries will no longer have that clause. Special savings law clauses. These clauses are called special because it attaches a specific right, or rather, it speaks to a specific right. It speaks to the right to not be subjected to inhuman or degrading treatment. Now, the special savings law clause saves the death penalty. So Jamaica used to have one. It was section 13(7), and it stated that nothing contained in or done under the authority of any law shall be held to be consistent or with or in contravention of subsection 6, to the extent that the law in question authorizes the infliction of any description of punishment which was lawful in Jamaica immediately before the commencement of the Charter of Fundamental Rights and Freedoms. That's, of course, we don't really deal with this anymore because we don't do the death penalty here. And that's why I say more Caribbean countries are amending their constitutions to get rid of these clauses, because it allows, the special savings law clause especially allows for the death penalty. And we now know that the death penalty is against the right to not be subjected to inhuman or degrading treatment. So how did we get here? Where we can amend the constitutions if these laws, if the clauses were there, how did we amend it? Because I'm sure you would have learned about constitutions and you would have learned about entrenched provisions, and you know that it's not so easy to change them. Now, I have here that these modern amended constitutions no longer have these clauses, or they don't have them applied, and the reason for this is because the court continues to find a way around them, especially the Caribbean Court of Justice and the Judicial Committee of the Privy Council, because they don't think that the citizens' right should be outweighed in great proportion. And many of these rights, especially the special of these clauses, especially the savings law clause, allows for the government to pass laws that are too great on the citizens' rights. So I have here that you should see Hughes and R and Spence, because Justice Saunders, who is the head of the Caribbean Court of Justice now, noted that a constitution is a living document, and the prohibition against inhuman treatment is peculiarly conditioned by evolving standards of decency. So basically saying we're evolving more. The world is changing, the law is changing, people have more rights, and the Constitution should uphold these rights. So these clauses prevent the Constitution from upholding these rights. He also said, the same person, Justice Saunders, also said in McEwan and the Attorney General, that if one part of the Constitution appears to run up against an individual fundamental right, then in interpreting the Constitution as a whole, and note this part that I underlined, courts should place a premium on affording the citizen his or her enjoyment of the fundamental right, unless there is some overriding public interest. In other words, the only way that we would uphold these limitations or these savings law clauses, special savings law clauses, especially those that the fact that they permit the death penalty, the only way you can even consider upholding those over those fundamental rights that we have in section 13(3) of our Constitution of Jamaica, or another section for another country, the only way any of these limitations, the court should allow these laws that limit these rights is if there is a public interest. If there's nothing to do with public interest, nothing to do with public order, then the fundamental right should be given. So in essence, the fundamental right of a Caribbean constitution is the epitome of the Constitution. It is the jewel of the Constitution because it gives the citizen their rights and freedoms. And the only way that a government can pass a law and the court allows that law that contravenes these rights and the court allows that law is if it has some public interest or it has something to do with public order. Remedies. Now, Jamaica has a redress clause, and most Caribbean countries, if not all constitutions, have a redress clause. Section 19(1) of Jamaica's constitution notes that if any person alleges that any of the provisions of this chapter, that's the chapter of fundamental rights and freedoms, has been, is being, or is likely to be contravened in relation to him, then without prejudice to any other action with respect to the same matter which is lawfully available, that person may apply to the Supreme Court for redress. So in other words, if any of your rights have been violated, you can apply to the Supreme Court for relief. It's section 91 for Jamaica, it's section 21 for Belize, and it is section 14(1) for Trinidad and Tobago. I want you to note that both persons or organizations can apply to the Supreme Court for relief. So persons meaning person A has their rights breached, they can apply to the Supreme Court. But organizations, for example, the Office of the Children's Advocate can bring a claim representing a child, although the General Office of the Children's Advocate has not been affected personally, but they represent every child in Jamaica who goes through something, and possibly 10 other children will go to them after this and say, hey, my rights have been breached, how do I get it solved? Or parents will go to them. And for that reason, because of the fact that they represent so many children in Jamaica, they can go and act on behalf of this child that claims that their rights have been breached. So there were cases that would usually say, oh, you shouldn't, companies can't represent a person, organizations can't represent a person, but that was canceled in McEwan and at the CCJ level, where the CCJ held that, hey, if a person comes with an issue of this sort, an organization is representing them, and the organization has a legitimate interest because they will represent others too, they can come in front of the court and seek relief. Now, redress does not only include judicial review, it includes special damages for some cases. But for the purposes of CAPE, we will stick to the syllabus, and your syllabus says we should look at judicial review. Give me a second. Now, Caribbean judicial review, and I got this from Fundamentals of Caribbean Constitutional Law. One of the leading authors in this case is actually the constitutional law teacher at the university, and she also teaches Caribbean human rights. So this is a good book. If you can get it, it's a good book to read for public law. So judicial review is the power and duty granted to superior courts to review laws and governmental actions to determine their consistency with the Constitution. Caribbean constitutions give jurisdiction to the High Court or the Supreme Court to provide effective remedies for breaches of guaranteed fundamental rights and freedoms. You can find this in section 19(3) of Jamaica's constitution, and it's in many other constitutions, if not all of them, which speaks to the fact that the Supreme Court and the High Court have the original jurisdiction to hear and to allow persons to be relieved after their rights have been infringed. So basically, just to sum it up, your rights have been infringed. Judicial review is where the court will review these laws and will determine if they're consistent with the Constitution, or they will declare that they're not consistent with the Constitution. So I have it here. It is the duty of the High Court or the Supreme Court to declare that a law passed by Parliament is ultra-virus to the Constitution. And you know that means inconsistent with the Constitution. And it is void if it infringes guaranteed rights. In newer constitutions, the High Court also has explicit jurisdiction to determine whether there has been a contravention of other things, other provisions in the Constitution that are not in the Bill of Rights. But we don't have to look at that because we're really looking at the Bill of Rights here. Grounds for judicial review, I would tell you to go read this case, Council of Civil Service and Minister for the Civil Service, or we call it a CCSU case, where the grounds for judicial review were given by Lord Diplock. He said the grounds, he gave 4 grounds, but we really look at 3 because the fourth one, it's not really, you can use it. And I do encourage you, if you're talking about grounds for review, use it, especially because you're talking about human rights and it's mainly focused on human rights. But it's not always assessed by everyone in every case. What is usually assessed is the first 3, which is illegality, irrationality, and procedural impropriety. But then the 4th one is possibly proportionality. You have to use it for human rights cases because it was built for human rights cases when we talk about the fact that the law passed should not be too great on your rights. But when I say it's not used in every case, is because this case is also, it's mainly used in administrative law. And most administrative law cases are not really human rights cases. So many people don't use it. But when you're dealing with constitutional law, I would advise you to use it. So illegality. Lord Diplock stated that by illegality as a ground for judicial review, and I use JR as judicial review, sorry for using the acronym. I mean that, so he said by illegality as a ground for judicial review, I mean that the decision maker must understand correctly the law that regulates his decision-making power and must give effect to it. So basically he's saying that when making their decisions in Parliament and they're passing, they must understand the Constitution and they must understand that this regulates their power and they must give effect to it, meaning they must pay attention to it. So the Constitution gives you power, you have to understand that the Constitution also gives the citizens rights, and you cannot pass a law that is legal or that does not follow the Constitution. Irrationality. He said that by irrationality, I mean what can now be succinctly referred to as Wensbury unreasonableness. And this applies to a decision which is so outrageous in its defiance of logic or of accepting moral standards that no sensible person who had applied his mind to the question to be decided could have arrived at it. So basically you see here that it's an objective test. And it speaks to the fact that the law that you pass cannot be so disturbing or so much on a person's right that no other Caribbean country, no other country in the world or procedural, impropriety. Lord Diplock said, I have described the third head as procedural impropriety rather than failure to observe basic rules of natural justice or failure to act with procedural fairness towards the person who will be affected by the decision. And the reason for this is that susceptibility to judicial review under this head covers also a failure by, well, this is mainly administrative, so I wouldn't really look too much at this. But what I want you to really look at is this law right here, proportionality. Note that proportionality is a ground for judicial review in the United Kingdom by virtue of the Human Rights Act of 1998. Now, you know that, and I think you would have learned that the United Kingdom is different from us in that they don't really have their constitution as one single document like we have ours, and you can look everywhere, you can see fundamental rights and freedoms. They just have a collection of laws, and that's what they use to guarantee people their human rights. So here they have the Human Rights Act of 1998. And it's understood to mean that if action to achieve a lawful objective is taken in a situation where it will restrict a fundamental right, the effects on the right must not be disproportionate to the public purpose sought to achieve. So for example, decided to revoke the license of a market trader who had urinated in the street, revocation would be out of proportion. That's an administrative case, but generally it is used in constitutional law to mean that whatever law you are given should not be too great on the person's right. So it should be in proportion with the person's right. So when you are passing a law, you should ensure that the law that you are passing is not over the fundamental rights and freedoms. If anything, the law you're passing, it should support the fundamental rights and freedoms. It should not violate the person's rights. So for example, you cannot pass a law that says Muslims can no longer walk in public wearing their, is a hijab, that's what it's called, because that would be too great on their fundamental right to religion. So you have to pass laws that are in proportion with persons' rights. And you can also see the Guyana Judicial Review Act, which speaks to the grounds upon which the court may grant relief by way of the remedies mentioned in this act include the following: breach of the principle of proportionality. So the Guyana Judicial Review Act speaks to the fact that if the government passes a law that is out of proportion or is too great on the citizens' rights, then that is grounds for judicial review. Past paper question. Assess the extent to which fundamental rights and clauses, give me a second. Assess the extent to which fundamental rights and rights clauses in the Constitution of a Caribbean Commonwealth country, state of your choice, preserve the rights of citizens. You can have that question, but that's not the question that I want to focus on. So I'll go to the second one because all is going on. I want you guys to be able to get a break and we do criminal law. You can go to your second class, your multiple choice class. All right, so attorney at law Rochelle Ming is representing herself for breaches of the Road Traffic Act. She is making submissions when Magistrate Davis interrupts her and said, "You know, Miss Ming, it is true that only a fool has himself as a lawyer." Miss Ming responds sharply and a heated exchange follows. Magistrate Davis tells Miss Ming to sit and she refuses. He cites her for contempt and commits her to prison for 7 days. Miss Ming brings an action against the government on the basis that in committing her to prison, the magistrate used unconstitutionality and that the magistrate exceeded his power by not simply fining her as the magistrate rules permit. With reference to decided cases and constitutions in a named Commonwealth country, identify the fundamental rights provisions which can support Miss Ming in her action against the government. Now, give me 1 second. All right, so I'm going to share my screen again, and I want you guys to tell me if you can see it. Are you seeing my screen? Are you seeing my? Oh, okay. All right, give me 1 second. All right, so make a note of provision G. the right to equality before the law. And make a note of H, the right to equitable and humane treatment by any public authority in exercise of their function. All right, so I think that's about it. To where, Daniel? To G and H? There. So I give you guys 2 minutes to make a note of that. All right. All right, are you seeing my screen now?
Yes, yes.
Yes, miss.
Okay. All right, so again, identify the fundamental rights provisions which can support misdemeanor action against the government. And the ones that I have is, as I said, G, the right to equality before the law. Although you guys can probably debate, I'm not sure if that one is really so much, but I know that H is for sure one of those provisions which says that the right to equality and humane treatment by any public authority in exercise of their function. That's a right that we all have. Now let's go back to the statement, or to the question, or to the scenario rather. So first he asked her if that it's a fool for her, that only a fool has himself as a lawyer, which really and truly there's no law preventing that. So if she wants to have herself as a lawyer, that is fine. And that started the exchange. And he asked her to sit, he asked her to sit, which means, frankly, if he says she's a fool for representing herself as a lawyer, and then he asks her to sit, you know what that means? He's not going to listen to the case. So she refused, and he cited her for contempt of court and committed her to prison for 7 days. So first of all, she did not get equality in front of the law and the judiciary, which is a public author. Go ahead, Javon.
I was going to say that I think the most obvious one as well is the right to due process.
Yes, sorry,
so-
I was going to make a note as well. All right, so I would say to take out G. So I would say take out 13G. Give me a second. Are you still seeing my screen?
Yep.
Okay. All right, 1 minute. All right, so take out 13G and put R, which is the right to due process as provided in section 16. All right, so everyone has that. Now the right to due process. So it's at R. So right here, the right to due process as provided in section 16. So just write that. So it's section 13, subsection 3, R. Tell me when I can continue. Oh, so my screen is not showing. Okay, all right. So just write this and I'll get back to it. Just write this down. So, right, Jamaica's Constitution, section 13, section 1(3), subsection 3, or you can put in brackets the number 3, subsection R, so put in brackets again R, the letter R, common letter, sorry, the common letter R. And then write the right to due process as provided in section 16. I'm going to share my screen again so that you can see section 16. So section 16(1), are you seeing my screen?
Yes, miss.
All right, so I want you to write down section 16(1), which says, whenever any person is charged with a criminal offense, he shall, unless the charge is withdrawn, be afforded a fair hearing within a reasonable time by an independent and impartial court established by law. So I want you guys to write that down. So I'll give you 3 minutes to write that down. Everyone has that? Can I move on now? All right, 1 more minute. All right, let's go. All right, so as your colleague would have pointed out, and as I would have said before, so your colleague pointed out duress, which you just wrote down. Letter H. Okay, yes, I'll repeat letter H. So letter, and then the other one that I said was letter H, which is the right to equitable and humane treatment by any public authority in exercise of their duties. So the right to equitable and humane treatment by any public authority in exercise of their duties. So I would identify those two. So H and R. So H and R, which speaks to equitable treatment before the law, before any public authority, or in equitable treatment from, sorry, any public authority in exercise of their duties, and then duress, which mainly means the fact that you should have the right to a fair hearing before an independent judiciary or tribunal. So he said that okay, someone is saying something? He said that she should sit, meaning he was not willing to listen to her because she's a lawyer and she's representing herself. And according to him, in his personal capacity or personal feelings, nothing to do with law as a judge or nothing to do with law itself saying that you can't represent yourself. It's just that he doesn't feel you should do it. So he says she should sit, meaning he was not willing to listen to the case. And when she refused to sit, he charged her for contempt of court and locked her in prison. Now, while contempt of court may actually, constitute a prison sentence, at the end of the day, how did they get to she refusing? Why did she have to refuse? Why did she commit the contempt? Not justifying the contempt or anything, but how did they get there? Someone else did something that was wrong, and it should be looked at. The judge, who in his public authority in his duty as a public authority representing the judiciary, an arm of government, would have refused to allow the person to speak and to represent herself, meaning he violated her right to due process, which is the first one, her right to due process or her right to a fair hearing for the Road Traffic Act, simply because she was a lawyer. And two, he violated the right for her to get equitable and humane treatment by a public authority. So I think that line of that first part where he says, Miss Ming, it is true that only a fool represents himself as a lawyer. And give me a second, guys. So that's the first part. That's the part that you need to focus on mainly. The fact that he first told her to sit and call her a lawyer, said only a fool. Only a fool represents himself as a lawyer, and then when he told her to sit, which denied her the opportunity to represent herself and to get her fair hearing. So that's the line that you would focus on when you identify the fundamental rights. I would say identify the two of them, and you can use that line as the explanation why you identified those two. B, explain how one remedy available to Miss Ming supports her action against the government. One remedy available to Miss Ming I'm guessing one remedy that is available to her would have been judicial review. And I guess this is where you talk about what is judicial review, and you will talk about the grounds for judicial review, and you can talk especially about proportionality, which means whatever is done should not be out of proportion to your rights. So whatever right or law given to the magistrate. Hold on, give me a second. Let me read over this question because I think I'm having a little bit of a confusion here. Miss Ming brings an action against the government on the basis that in committing her to prison, the magistrate acted unconstitutionally and that the magistrate exceeded his powers by not simply fining her as a magistrate rules permit. And Jada just said there's an abuse of discretion, and thank you for that. So that is true. So the magistrate rules, as I would have spoken to you about the civil procedure rules before and the criminal procedure rules and rules of the court that judges must follow when they're actually making a sentence or dealing with a case, whatever case it may be, they are expected to follow certain rules. And in this case, the judge would have violated that rule. I think one remedy I would have used here is that she may have a special case of damages, but CXC did not speak to that. They spoke to judicial review. And I don't think judicial review is really, go ahead, Javon.
Oh, my apologies. I think the remedy that would pertain to this is a prohibition order, which is within the scope of the syllabus. Damages, I'm not certain I would go with because of the nature of the subject matter, which is public. So the prohibition order would be available to prevent the public bodies, such as the court, from acting or continuing to act ultra vires or contrary to natural justice. So the upper court would give a prohibition order to the lower court or tribunal, requiring it to cease proceedings that were done before or to correct the wrong that was done.
Okay, thank you, Javon. And Crystal, yes. So yes, Javon, I agree with you. So one, I don't think judicial, well, not that I don't think, judicial review is not applicable here because, go ahead. Someone is talking, go ahead.
So it's Samoya. Hi students. Javon, that's your name? That's the name? I'm hoping it's pronounced correctly.
Yeah, it's pronounced.
Okay, so I'm happy you mentioned prohibition. Could you explain to us, or rather elaborate, on what exactly is prohibition? Because no, it's not damages, but what exactly is it? Because what we fear that as tutors, that because we're also law students, Ms. Morris can agree with me, because we're also law students going into third year, we can get so in depth in these things. But at the CAPE level, especially at Unit 1, you guys merely kind of touch the surface of the topic. But I'm very happy that you seem to have an understanding of what prohibition is, but not everybody here may know what exactly does it fall under. So if it's not damages, what is it?
Okay.
Okay. It's a what?
I'm sorry?
What is it? It's not a damage. It's not considered damages. What is it?
Oh,
prohibition, okay. Injunctions, what are they?
It's a remedy on the judicial review. So like on the judicial review, you have remedies that addresses public law and you have remedies which address private law, right? And so the damages would address private law. The prohibition order would address public law. So the prohibition order essentially is an order to a lower court, a tribunal or similar decision-making body requiring to cease proceedings. And so the order should seek to
do what?
To correct the failure of a body that would have
public.
acted, so the court, so the public body that would have acted. And
Sorry,
so,
out of, yes.
right, and so the order should start where a body has failed to exercise its jurisdiction
Not just
properly.
a body, not just a body. You're on the right track. What I want you to get, and I want you guys to get into the habit of going in depth in your thinking and not presuming that the person you're talking to knows and can fill in the gap. So not just a body, but a public body, or a public authority, public individual who operates within a public office.
Right.
Mm-hmm.
And
right.
so, right, okay.
All right, great. Thank you, Ms. Morris. Go ahead.
Okay. All right. So I do hope that that was clear for everyone. So it would not be damages, and it would not be, as Javon said, it would not be judicial review in its private capacity. So it would be in its public capacity, and it would be a prohibition order where the lower court can rule that, the higher court, sorry, can rule that the lower court was wrong in their behavior or in how they handled the matter. C, with reference to the fundamental rights provision identified at A, which again we know is H, that public authorities should not be inhumane to persons. Rather, persons should have equal and humane treatment rather by public authorities. And then the second one that we identified is that her right to duress was also infringed. So with reference to the fundamental rights provision identified at A, assess the effectiveness of this provision in protecting the rights of citizens. So I kind of want to hear you guys on this, because I do think that everyone might actually have a different answer, and especially because it's an essay. And I don't just want to give you, because a while ago I was giving you what I thought, and there we go that Javon actually gave a different answer. So I want you guys to kind of pitch in here, and I kind of want to hear from somebody else other than Javon, that with reference to the fundamental rights, which is H and R, which we identified at 1, assess the effectiveness of this or these provisions rather in protecting the rights of citizens. How does the right to duress protect a citizen? How does the right to not be subjected to inhumane treatment by public authority protect a citizen? Anyone? Crystal? How does the rights that you identified in A assess the effective, or well, I want you to look at how does these rights help in protecting the rights of citizens? How does these fundamental provisions rather help to protect the rights of citizens? So are they effective? Do they protect the rights of citizens? Okay, Crystal, no problem. Anyone else? All right, so if we didn't have any right to duress, what would happen in court? If you don't have the right, if we didn't have any right to duress, and you go to court with a situation and you're frankly innocent, what would happen? If the judge could just say, well, I don't want to hear you. You did something wrong. I think you do something wrong. I don't want to hear your side of the story. I don't care about your lawyer's side of the story. I feel like you killed the man. You're going to prison. You didn't have a right to a fair hearing. Do you think that is right?
No, miss.
All right, so Javon answered. So Javon said it would be the will of the public body, the court, to determine someone's justice or course of justice, which is really the essence of it. And with the right at age, which says that it's inhumane for public authorities to like not, public authorities, sorry, shouldn't allow people to not be treated humanly or equally. That is a right that is important, because if that was not the case, then, you know, when police come to you and all the things that we always argue about with the police, like they beat people and they don't arrest you how you're supposed to be arrested. They probably would have taken statements from minors. A lot of things would have probably been done that should not have been done. A lot of false imprisonments would have occurred. You know that when you see police go into a garrison community and they take a number of boys and they bring them down to the station, if they question them and they take statements and they do what they're supposed to do and there's no evidence, they have to let them go. But if we did not have any rules protecting us from arbitrary power by public authorities, then you would have had a case where persons would have gone to prison and they would have been locked up for days, months, years, even when there was no evidence against them. Or they would have been brought before the courts, and the courts who is able to, the public authority or the judges who are able to make their own decisions and decide what is going to happen to you, would have sentenced these persons to probably even life in prison for a crime, and they have no evidence that they did the crime. And if you have no right to due process, that is even worse, because you get no hearing, you get nothing from the director of public prosecution to say, well, you did this, that is wrong. Nothing from your defense lawyer cannot defend you to say, well, you here's evidence that you did not do anything wrong. And so you would have innocent people who really did nothing wrong going to prison for years. And you know, there are cases where we have had people at the GG's discretion who have been in court in prison for 30 odd years because they were not given a fair hearing. And one of those cases was, I think it was last year or the year before, where one of our criminal law tutors at the university had defended that person, where they were in prison for 30 odd years because they were not given a fair hearing. So it is important that these laws, these provisions, these fundamental provisions are effective in protecting citizens' rights, because it protects them from arbitrary power by public authority and ensures that whoever is being charged, that whoever is going to prison or all of that, it's only persons who have committed the crime and not innocent people. So I hope you guys got that. These rights are effective because it protects us from arbitrary power by public authorities, and it ensures that only criminals go to prison. It ensures that persons who have done nothing wrong. Thank you, Javon. So yes, it's Noel Chambers. So Noel Chambers was not given a fair hearing, and he was left in prison for years without a trial. No, that is unfair. But if we did not have the right to due process, so imagine that's one man, and probably there are a few others, but imagine if we did not have the right to due process, probably hundreds of people would have gone to prison for years for something they did not do because they were not given a fair hearing. So that is why the right is important. So if you discuss that, and if you discuss both of them, then you should get your marks. Any questions? Before we go into the break, any questions? All right, so we are going to go into another 10-minute break. Can you sue the judge after not getting a? I will not tread those waters. I really don't think so. I just think it's reviewed by the higher court, and the higher court may give you a remedy. So they may give you relief, but by reviewing what has been done and make a declaration or anything of the sort. But I really don't think they will sue. I really don't think you can sue the judge. But I don't want to say yes and I don't want to say no, but I've never really heard of someone suing a judge. So I'm not going to say yes and tread those waters and then I'm incorrect. So I will just leave that one alone. Do not go into your exam and talk about suing a judge because I don't have any proof of that. So I won't say that. Crystal, could you write about the components of a fair hearing for the last part of your question? Sure, it's an essay and it's 10 marks. So if you do know the components, you can put them there. But please ensure that at the end of the day, you do answer the question and you do not just have everything about due process and not type back in or answer the question. No, that Daniel is fine. I know that you're just asking. I'm just saying, from my point of view, I'm going to protect you guys. Please don't because I know sometimes we're in exam and sometimes things come up and we're really not sure. We might put it there. Please, if you're not sure, leave it because they will mark you down for it. I mean, one of the advantages that you guys have is that CAPE is they're scripture writers. So once you have like an introduction, your conclusion, your body paragraphs, your law and everything, you have to get a mark. But they can still mark you down if you do write something that they know that you shouldn't have. So just be careful. Any other questions? All right, guys. So I'm going to give you a 10-minute, or well, a 15-minute break. Sorry, you've been through 2 sessions and we'll do criminal law after. So I'm going to give you a 15-minute break and we will return at 1:10. All right, so just to confirm, everyone is seeing my screen?
Yes, yes.
Yes, miss.
Okay. Give me 1 second. All right, so for module 3, criminal law, the broad topics that I see is that you should focus on the elements and types of criminal liability. Now, what is criminal law? We would have spoken about it before, but just to remind you, it's a system of laws concerned with punishment of offenders or individuals who commit a crime. And adopted from Card-Cross and Jones, a crime is a legal wrong for which the offender is liable to be prosecuted by or in the name of the state. And if found guilty, they're liable to be punished. I know that your study guide has, I think it's Smith. There's another definition. It's the same definition. It's just that it's 2 different textbooks. So you can use either one you're comfortable with. Criminal law is concerned with protecting the society and punishing those who threaten the law and order of society. It also sets out clearly how persons should behave and the consequences of disobeying these orders. And it was, as we have said multiple times this morning, it's between the offender or the accused and the state. So please do not forget that. Criminal liability. The elements of criminal liability are actus reus, mens rea, and lack of a valid defense. So basically, actus reus plus mens rea plus lack of a valid defense equal criminal liability. Meaning, a guilty action plus a guilty mind plus no defense against it. Like, for example, self-defense, you're defending yourself, then there's criminal liability. One cannot work without the other. So you must ensure that the person has a guilty mind, guilty actions, and there's nothing that they can use to defend themselves. Then once those things are available, they can be held criminally liable. So the definition of criminal liability, so Smith and Hogan, which is the text that is referred to in your study guide, it is a general principle of criminal law that a person should be there. So may not be convicted of a crime unless the prosecution have proved beyond a reasonable doubt both that A, he caused a certain state of affairs which is forbidden by criminal law, and B, that he had a defined state of mind in relation to the causing of the event or the existence of the state of affairs. The event or state of affairs is called the actus reus, and the state of mind is the mens rea of the crime. So again, guilty mind, guilty act, no defense, criminal liability. Now, actus reus, the guilty act, it refers to the law action or conduct which is a constituent element of a crime, as opposed to the mental state of the accused. So actus reus don't really mean has, though they coincide with each other, actus reus does not speak with your mind or to what's going on in your mind. It speaks to your actions, which is why you may have offenses where there might be an actus reus, but then the argument is really that there's no mens rea, because actus reus is what you do. So I slap you, I shot you, I stab you. That is the actus reus. It has nothing to do with what state my mind was in or what was going through my mind. Note well that the actus reus, it includes all the physical elements of the offense, to include the consequences of the prescribed conduct and surrounding circumstances. And surrounding circumstances here means the state of affairs must be such as to be able to attribute responsibility to the accused. In other words, it brings us to the first principle of actus reus, which is that the act must be done by the defendant. But before we get there, prescribed conduct speaks to acts of commission and acts of omission or state of affairs. So acts of commissions, this is an act that the person actually does, while omission is failure to act when you should have acted. So with commission, it's, for example, commission, I actually stab you or actually shot you or wouldn't even intend anything that happens. That is the commission. So acts of commission can be divided into two parts: conduct crimes, what the person did, and result crimes, which are the consequences of such actions. And I have an example here. Mark was speeding. Speeding is the conduct crime, because speeding is actually a crime, but that's the active process of what he was doing. And in the result crime now, which would be that he hits Alice while she was crossing the road. So usually, yeah, so that's it. So in conduct crime, he was speeding, and the result crime, he hits a pedestrian. Acts of omission, this is failure to act in a situation which the law has imposed a duty on the defendant to do. And this is usually in like cases of negligence. You have a duty, or you have voluntarily taking a duty to care for your sick aunt. It cannot be a case that you left your aunt to sit on the couch and to live off her own body because like you're not feeding her, you don't allow her to use the restroom and all of that. That is that's an act of omission, because you failed to take care of your aunt when you should have, because you took on the duty of caring for her. So, and then what I have a note here, one cannot be charged for inaction unless it is a case where the law imposes a duty to act. So, for example, you cannot be charged for refusing to drive on a route with street lights, but you can be charged for driving without lights on your vehicle, which is why, because the Road Traffic Act requires for you to do so. You must drive with lights so that you can see where you're going and that you don't hit on anybody. But if I decide that I'm not going to drive on King Street, nobody can charge me for not driving on King Street, but they can charge me for not using the light. So with acts of omission, it's failure to do something that the law has prescribed or has given a duty for you to do. The only other way to charge for inaction is in a case where the defendant of an offense is the definition of an offense is expressed in terms which refer to an omission. Now, a duty to act. There are three ways that you can have a duty to act. A contractual duty, A and B enter into an agreement, and automatically it is expected that once you have a legal agreement, both persons will uphold their end of the bargain. If you fail to uphold your end of the bargain, you would have failed your contractual duty. And usually where contractual duty arises, it's not really when we think about just two friends who entered into an agreement and they have a document saying they're in a contract, that might be a civil matter more than likely. But when we talk about contractual duty, most times we usually look to companies where a company might have a contractual duty, or they may have signed on that to say, you know, okay, we will protect you and we will not bring anything to harm you. And if they do nothing or they fail to act and they fail their contractual duty and you die on their job, then they may have failed to act when they're supposed to because of the duty that they have to. Their statutory duty and their special relationship. I want you to note that if the person created a dangerous situation, or if they hold a public office, or if they voluntarily undertake to care for those who are unable to care for themselves, this is also where a duty to act also arises in these situations. So contractual duty. So here, imposed on one by virtue of a contract, thus giving them the responsibility to protect or prevent harm from reaching the person to which they have a duty over. And the case here is that I suggested here that you can use is RV Pitwood. I would encourage you to use it. Here, D worked as a gatekeeper for a railway company. Thus, he had a duty to close the gate whenever the train was passing. On one occasion, D left the gate open and went for lunch. During this time, a car passed through the open gate and a driver was killed, which saw D being charged for manslaughter by gross negligence. The issue was whether a duty of care was within his contract, which would render D criminally liable, as well as whether the omission could amount to the charges laid against D. D's appeal was dismissed on the grounds that he breached his contractual duty when he failed to shut the gate. His duty, according to his contract, required that he shuts the gate, and by failing to do so, he is to be held criminally liable. It was also held that he was under a contractual duty to protect the public from harm, which was breached. It was made clear that the railroad was a public road and that the company had a duty to protect the public when using this road. Special relationship. The duty imposed at law, which gives them responsibility to protect a specific person, thus establishing a special relationship between the two. For example, parents and child, or legal guardian and child. The guardian has a responsibility at law to protect that child. Therefore, you can't leave the child at home alone. You cannot allow them to go on the road alone. And I'm talking about children here. Like, listen, you cannot allow a 5-year-old to be going to the shop. It's not right. People do it though. If anything happens to them on the road and there's no parent or guardian who should have taken the responsibility to protect them, they can be charged because there is a special relationship between the two. And this special relationship have established a duty to act. If you leave the child alone, and unfortunately, there's a fire and the place burned down, okay, yes, Crystal. Guys, what I would advise you to do as well is to you're sending a direct message to me, but I would say send it to everyone so that other persons can also see what you're talking about, because a lot of the things that you're sending me are actually good, but I can't other persons can't see them. So Crystal was actually suggesting the local parentis principle, which has, yes, which established a responsibility for some person or organization to perform the duties of a parent. So for example, when you talk about the whole guardian thing, where your guardian might not actually be your biological mother or father, but locus parentis gives them that duty to act in the capacity as your mother or father, and that establishes that special relationship. And Javon said the school environment as well, and that is true. School environment, if the child goes to church and they go to children's church, wherever they go, wherever they go. All right, so guys, I ask you to pay attention to the chat as well, because things are coming in and they're actually good for you right now. So wherever a child frequents, where adults are, those persons automatically, so if they go to a counselor, guidance counselor, those persons automatically take on that role of a parent, and it establishes that special relationship. And if anything happens to the child, go ahead, Javon.
Right. I was just gonna give an example. So this year I had to report something to the school that happened outside of the school that involved cyberbullying, and I had to report it to the guidance counselor, and she had a care under the Child Care Protection Act, and in line with the Education Act, because it's outlined there as well, to report it to the senior members of the school. So had she not acted, and then I would have acted in the form of maybe even self-harm, for example, which was not probable, but just for hypothetical sake, she would be liable for criminal prosecution.
Yes, Javon, sorry, that is true. And that arises especially in, I want to be careful, but it arises especially in sexual abuse cases. Right? So if a child goes to a guidance counselor and say, hey, daddy is touching me, or uncle is touching me, or a friend or whoever is touching me, and the guidance counselor does not report that, or if they find out that a child is pregnant and they do not take the necessary steps to contact the police so that an assessment can be done to see who is responsible for that pregnancy, then the guidance counselor under the Child Care and Protection Act can be arrested and charged, convicted, and sentenced. So, special relationship, as we said before, someone else said something in the chat? Especially those homes for children. Yes, Brittany, that is so true. Especially those homes for children. Because we have seen a lot of cases, and it is very unfortunate, where a lot of some of the places that our children get hurt the most are sometimes these homes where one person, you might find a warden doing something wrong, and it shouldn't be, because there is a special relationship between those who are in charge of the home and the child, because they have a duty to act. And if you find out that one warden is doing something to another child, not because it's your friend or your colleague or whatever, it's wrong. And if you fail to report it or you fail to do something about it, then you would have breached your duty and you too can be arrested. So again, the duty imposed that law, which gives them a responsibility to protect a specific person, thus enabling a special relationship between the two. And another school that I want you guys to also take note of, and it doesn't, I've never really seen or heard of it in Jamaica, or well, there may be cases in Jamaica, but we haven't really visited that a lot. But it has happened a lot, especially in like England, in a lot of the English cases that we read, boarding schools or churches that allow kids to board there. So you can use those examples as well. I have here the case R.V. Gibbons and Proctor. And in this case, D, along with his partner, neglected his daughter, who starved to death. The defendants were charged with murder. However, they argued that it was an omission and that they did not constitute the act required for murder, even though they had a duty of care over the child. The issue was whether the defendants were liable for murder. The court held that the defendants were liable for murder, as murder can be committed when the defendants have a duty of care over the victim. The court held that the father, by virtue of being biologically related, assumed the duty of care over the child, and his partner, although not biologically related, had taken money from her partner, which could have been used to feed the child. It was held that deliberately starving someone to death must be capable of constituting murder. And Daniel said R.V. Adamako. I was going to use that case. It can be used there. It can be used a lot of places, to be honest, but I was going to use it for public office or for professional responsibility, where one automatically has a duty to act by virtue of the office or the position that you hold. So it is expected, as we were speaking about before, that a teacher, someone is talking? Yes, Javon. Javon noted a prescribed person duty to report need for care and protection. And back to public office. So I was saying, like we were saying before, that a teacher has that duty to act. Here we're talking about, this case was about a doctor. So he was yes, Brittany. Guys, I'm reading your things in the chat. So when you see I stop, I actually read to find what you're saying. So don't, I'm not just going silent for no reason. So and Adamako, so here the defendant was a anesthetist, I probably pronounced that wrong, during an eye operation on a patient. During the operation, the tube from the ventilator supplying oxygen to the patient became disconnected. The defendant failed to notice the disconnection for some 6 minutes before the patient suffered a cardiac arrest, from which he subsequently died. The defendant was charged with manslaughter, and this is because in his capacity as a doctor, in his public office, in his professional responsibility, he has a duty to act to ensure that there was no disconnection and that everything was in place and that the patient was safe. And because he failed to do that for all of 6 minutes, he was charged for manslaughter. He did not have any intention to kill the patient, and he wasn't charged for murder. But he was charged for manslaughter because of gross negligence. Duty to act again, and we're looking at voluntarily undertaking care. This is one's choice to voluntarily undertake the responsibilities legally to care for a person who is ill, injured, or generally unable to help themselves. So if you have undertaken to take care, of your of someone who's disabled or of your elderly grandparents or great-grandparents, then you must do everything within your power to ensure that they're okay. And that is your legal duty to act because you have voluntarily undertaken to take care of them. So in Ironstone and Dobson, in this case, the defendants lived together in an apartment along with their disabled son. The defendant's sister came to lodge at their dwelling and neglected herself to the extent where she became immobile, bedridden, and unable to take care of herself. During the time, the defendants did not report the issue to anyone, neither did they seek medical assistance for the victim after they failed. These only attempts to assist was, these only attempt to assist was only evident when he tried to wash his sister with the aid of a neighbor. The victim eventually died as a result of immobilization, infected bed sores, and malnutrition. Defendants were charged on the grounds that they had undertaken the care of someone who was only able to care for herself. The issue was whether the defendants were criminally liable for manslaughter. The appeal was dismissed as the court held that the jury was to assume that defendants undertook the care for the victim, as since the middle of July 1975, when the victim began to lodge with them, she was unable to help herself, and the appellants undertook the responsibility and were able to carry out this duty by seeking help or doing it themselves. It was held that the appellants had been reckless as they were indifferent to the risk to infirm person's health. State of affairs. This refers to criminal offenses that do not require an act of commission, and neither is there a need for an act of commission. That is, does the defendant does not need to act, nor did they fail to act. So in R and Larsona, in this case, a French subject was deported against her will from Ireland to England by the Irish authorities on account of a condition in her passport requiring her immediate departure from the United Kingdom on a certain date. Upon her arrival, she was immediately charged and later convicted of the offense of being an illegal alien to whom leave to land in the UK was refused pursuant to Articles 1, 3G and 18(1)B of Aliens Order 1920. The Court of Criminal Appeal held that in Article 1(4) of the order, the French subject was deemed to be in the class of persons whose landing was prohibited. By being found in the UK after the date limited the condition of her passport, she committed an offense with which she was charged, and the circumstances which she returned to the UK was immaterial. So there are cases where you really didn't act, you didn't commit the act or you didn't fail to act, but because of the surrounding circumstances, you may have actually, you can be charged for breaching your legal duty. The act must be voluntary. So I had introduced this earlier, and I'm going to get into it now. So for someone to have the act, so this is the first principle of the actus reus. For someone to have the actus reus of a crime, the act must be voluntary, which means they must do it from their own free will. And free will does not exist if the defendant has an ailment or illness which prevents them from acting like a normal person. So we usually talk about automatism or paralysis, seizures, disease, unconsciousness, all of that, because you cannot, if you're driving and your disease, overtake you, then you never had the intention to actually kill somebody or to hit down anybody, but it's because of your disease. But I want you to note that the defendant may still be liable if they saw that in their state they could have created an offense. So for example, you were having seizures before and you were having it regularly throughout the day. Why would you decide to take yourself and go in a car and drive, and you know that by after 10 minutes of driving, you're going to have a seizure and you're possibly going to hit down a pedestrian? So you would not be able to rely on a defense there, because it was your free will not to hit down the person, but it was your free will to drive the car knowing that you were going through the seizures. Causation. For there to be an actus reus for a crime, the victim's actions must be the actual cause of the crime. In other words, causation is whether the defendant's act or omission caused the harm experienced by the victim. There can be factual causation or legal causation. We'll focus on factual causation, especially for Cape. All right, so Brittany said, was driving with a lady and the blue flashing police lights always made her get dizzy and blackouts. It was in the early morning and she almost hit someone. Scary time. And you see, that is what we're talking about. If you know that you have some special things, like some people say they can't drive at night because they know that if they drive at night, they're not going to see the road. Why are you going to take up yourself and go and drive at night and then you hit on somebody? And you know that you have an eye disease, you have cataract or glaucoma or something, and you know that you're not seeing well or you're seeing only 50%, and you take up yourself and go drive a car at night and then you hit down somebody. At the end of the day, while your disease may really be the cause why you couldn't see the road and you hit down somebody, sorry, in essence, you still knew that you still knew that if you went into the car, that would have happened. And so free will still comes into play. Go ahead, Jada.
So, Miss, basically you would use the but-for test of causation.
Yes, I'm going to get into the but-for test because we're going to focus on factual causation for the purposes of your exam. Daniel, what if it is an intervening act or event which is unconnected to the defendant's act? They wouldn't be liable then. No, Daniel, that's where we're going to discuss that when we're going to the but-for test. So the but-for test is really that, but for the defendant's actions, would it have happened? If it's a case where the defendant stabbed you, but you went into the hospital and your wounds had started to heal, and the hospital, because someone pulled some plug or pulled the drip or pulled something, you end up dying, then there would have been a break in the chain of causation because your wounds would have healed, so the stab would not have killed you. So the but-for, that's where the but-for test come in. So this is where we look at, it comes under factual causation. So the but-for test is applied here. But for the defense's actions with the harmful consequences have happened, when and how it did. So causation, critics, there are actually critics to the but-for test. There are actually critics to the but-for test. So some critics do not support the but-for test where there are intervening acts. For example, A and B got into an argument. A pulled a knife and stabbed B. B was rushed to the hospital where he received treatment for his stab wounds and was healing. However, due to the failure of the nurse to provide B with necessary medication, B died. The but-for test would not be effective here as the wounds created by A were already treated and being healing. So that's the essence of the but-for test. But for the defendant's actions, would the harmful consequences have happened? Some people don't really like it because they're saying most times that the whole breaking causation, there's actually no, the argument about breaking causation don't actually succeed. So many people don't like it because they really believe that if something happened and you go to the hospital and the nurse is negligent, there's no way you should hold someone liable for it. So one of the cases I have here is R.V. Jordan. In this case, the defendant was the defendant Jordan stabbed the victim who died in hospital 8 days later. An autopsy showed that the victim died from bronchopneumonia following the abdominal injury sustained. The court at first instance found Jordan guilty. However, the doctor who treated the victim did not believe this was a cause of death. The issues were whether the court could listen to additional evidence and whether there was some intervening event which led to the victim's death. The Court of Appeal, in allowing the defendant's appeal against a conviction for murder by stabbing, held that there was medical evidence that had not been in any true sense been available at the trial, and it had been plain in the instance case that had the jury heard that evidence, it would have hesitated long before finding that it was satisfied that death was from the stab wound. This is because additional evidence, which they did not see, suggested that death was not caused by the wound, but it was caused by inappropriate medical treatment. The victim was intolerant to a certain medication, which was noticed and initially stopped before being continued the following day by another doctor. But because it was already introduced to the victim in abnormal qualities, it waterlogged the victim's lungs, and that is what caused death. So this showed the but-for test and it showed the break in causation. So if you're going to talk about causation, then and you don't have R and Jordan, I would advise you to use, even if you have other cases on the area, I would advise you to just use this as your leading case. Mens rea. The term mens rea refers to the state of mind expressly or impliedly required by the definition of the offense charge, Card, Cross, and Jones. Mens rea is required to establish the blameworthiness or fault. One cannot be criminally liable. Someone is talking. One cannot be criminally liable if they only committed the action. Maybe if you commit the action alone and you don't have the mental element, there are other things and especially when it comes down to murder, if you don't have the mental element for murder, they can charge you for some other offenses against the person, but they cannot charge you for murder if you did not have the intention to kill the person. So without mens rea or the state of mind, or simply without the intention to commit a crime, you cannot be criminally liable. Yes, Javon, I am going to get to that. So I'll get to that. I'll get to that topic soon. So levels of mens rea in order from high priority to low. The highest is intention. The second highest is recklessness, and then negligence. And negligence should actually be gross negligence. So it's not just any random negligent matter. It has to be gross negligence, which means it's so serious and so disturbing that you can be held criminally liable instead of being taken to court in a tort matter. All right, so mens rea, the intention. This is the highest degree of mens rea, as I said before, and it can be either direct or oblique. Direct intention means you literally had the intention to go and kill this specific person. So I have an example here where D killed B, but before he killed him, he had invited him into his room and he had the gun in hand. He had the direct intention to kill him because he was able to foresee what the result would have been. He knows why he was calling him in his room. It's either he intended to kill him or to cause serious bodily harm. And because of that, it can be said that he had the direct intention. But you also have indirect or oblique intention, where you may not yes, Daniel, R.V. Willing would have established the two-stage test. So in regards to oblique intention, where the person must be able to foresee that their actions would have caused some form of negative result, whether they had want to kill the person or not. So I had an example here where D planned to kill B, but he went to the restaurant where B frequents and sprayed the entire restaurant with bullets, and 10 persons, which did not even include B, died. While he did not aim to kill those 10 persons, he had an oblique intention, because he should have been able to foresee that once I go and shut up, or once I go and bomb up a restaurant, everybody in there is either going to get seriously hurt or they're going to die. So while he did not have the direct intention, he had the oblique intention. So to wrap that up, you can have either direct or oblique intention. So cases for oblique intention, I started with R and I am. And in this case, the defendant had a relationship with a man who became engaged to be married to B. On the morning of July 15, 1972, she went to B's house and poured petrol through the letterbox, stuffed newspaper through, and lit it. She gave B no warning, but went home, leaving the house burning. B escaped from the house, but her two daughters were suffocated by the fumes of the fire. The defendant was charged with their murder. The defense was that she had set the fire to the house only in order to frighten B, so that she would leave the neighborhood. So that she would leave the neighborhood. Ackner J. directed the jury that the prosecution had to prove beyond a reasonable doubt that the defendant had intended to kill or do serious bodily harm to B, and that if they were satisfied that when she set fire to the house, she knew that it was highly probable that the fire would cause death or serious bodily harm, then the prosecution had proved the necessary intent, and that it mattered not if her motive was to frighten B. He then advised the jury that to concentrate on the intent to do seriously bodily harm rather than the intent to kill. The defendant was convicted of murder. It was held under Section 8 of the Criminal Justice Act that the defendant was guilty of murder if it was established that she herself had foreseen that death or grievous bodily harm would or might very probably result from her action. And accordingly, the judge had correctly directed the jury that if the defendant knew that it was highly probable that the fire would cause death or serious bodily harm, her motive to frighten B was immaterial. I also made note of the of RV willing, which someone had indicated before, Daniel. So the leading case, so although I place I am there, I would invite you to write about willing first and then use I am as your supporting case. So the leading case is RV willing, as this is where a test was actually established for oblique intention, and that is the Willing's two-stage test. So the test is, well, as I said, it's two parts. So part one is that we must consider if the undesired consequence was virtually certain. Of course, you know that if you set fire to a house, just going back to Hyam there, because I haven't put the facts of willing here, but I'm just saying, using the willing two-stage test as a guide for Hyam, you don't think it's virtually certain that if you set fire to a house, it's either the smoke will kill the person or they're going to be frightened. What if or they're going to die because from the fire, from being burned? Because you say you want to frighten the person, but what if the person is sleeping? You think they're just going to smell the smoke? What is a dead sleeper? You know, you have people who sleep dead. Then if a pin drop, they won't know. If the house are burned down, they won't know. If gunshots are being, they won't know because they sleep so dead. You don't take that into consideration. That setting fires to someone's house, and depending on how fast the fire spread, it would have killed the person, or if it don't kill them, they would have suffered at least second degree or first degree burns. So from applying the Willing's two-stage test to the case that we discussed before, we will see that it's virtually certain. Anybody, although oblique intention is not really an objective test, but still, you as a person as a subjective test, you as a person should know that it's virtually certain that they will either die or suffer serious bodily harm from that. And did the defendant appreciate this? That's the second part of the Willing's test, which means did the defendant see the risk and take the risk anyways. I want you to note that intention is not motive. Motive is not. Torian said, could it be a case that she did not know they were inside? Torian, I would say she knows that they were inside because she said she did it to frighten her. So I'm assuming that she waited until she knew that she was there to go and try to set fire to the premises, because she wouldn't just try to frighten her if she knew that she wasn't there. So intention is not motive. Motive is a reason for committing the crime. So for example, I want to kill somebody because they slapped me. So I decide I'm going to kill them. Or I want to kill somebody because they stole something from me. I want to kill somebody because they stole something from me, or they took some money, I loaned them some money and they haven't paid it, so I'm going to kill them. And so the police can establish that that was my motive, my reason for committing the crime. The person took my money and they don't give me back. But intention, on the other hand, is I'm in my mind saying I'm going to shoot this person and I'm going to kill them and I want to ensure that they're dead. So intention is more the thought that I'm going to kill you, while motive or the purpose of doing it, I want to kill you, I want to get you dead, or I want to get you seriously injured. But motive is the reason why I want to get you dead, or why I want to kill you, or why I want to see you seriously injured. So mens rea and recklessness. This falls under what is known as basic intent offenses. So you have basic intent of offenses and you have strict liability offenses. So recklessness falls under basic intent offenses. Recklessness means the taking of an unreasonable risk of which the risk taker is aware. So recklessness therefore is established when the defendant sees danger or harm and decides to run the risk. So for example, D has a fish gun and he knows that it is the gun that if the gun actually goes off will harm B, who is less than 6 feet in front of him. D decides to test out the gun anyways, it goes off and kills B. D would be reckless in a situation because he saw the risk and took the risk anyway. The level of recklessness is not as high as intention, but oftentimes in cases like these, the defendant did not specifically want to cause death or harm. However, because they were not keen on what they were doing or decided to run the risk, they caused injury or death to another, which is why it's not as high as intention, because if you have direct intention, you want the person to die. But if you are reckless, it means you didn't necessarily want them to die, but you saw that there was a risk of injury or death and you still took it anyways. All right, so recklessness, subjective recklessness. So the leading case here is R and Cunningham. And the principle laid down in this case relating to subjective recklessness is that the accused must have demonstrated an actual intention to do the particular kind of harm that in fact was done. And the accused must have foreseen that the particular kind of harm might be done and still took the risk. Objective recklessness, on the other hand, the question here is whether a reasonable man would have acted the way the accused did. See R and Cadwell. Note, this test does not apply to offenses against the person, such as homicide, assault, rape, protection of women and girls, kidnapping and abortions, and infanticide. So when it comes to offenses against the person, we look at the subjective test. Gross negligence. This is failure to exercise the standard of care that a reasonable person would have taken, and the failure to exercise the standard of care results in the harm or unlawful act. It is also failure to act where there's a legal duty to do so, and we can look back at R.V. Adamako, which we looked at earlier on. Strict liability, which Devon would have indicated in the chat some minutes ago. Now, this refers to an offense or action in which mens rea is not required in respect of one or more elements of the actus reus being present. Public policy is usually one of those areas where no mens rea is required and the burden of proof would be on the accused and not on the prosecution. It also applies to those offenses implied by statutes such as the road traffic offenses and the fairly new area, which is the protection of the environment. So for example, road traffic access, you shouldn't run a red light. You run a red light and you hit someone and they die. You don't need to come to court and prove whether you had the mind to kill the person or not. It's a strict liability offense. It's actually a part of statute, it's actually a part of law. You went against the statute and you will be charged. Cases that I have here to look at is Sweet and Parsley, R.V. McNorma, Alpha Cell and Woodhard, because they are in your study guide. And I also had a Pharmaceutical Society of Great Britain and Stark Wayne Limited, and then Gamma and Hong Kong Limited, which I think is the leading case. And I'll say why I say that, why I think that, because if there is no statute, the court is likely to apply the Gammon principle, which I noted that, sorry. But basically the Gammon principle was saying that where there's no mens rea, the case can still go on as long as it is a public policy case or something of public interest. So strict liability and transferred malice, this is where a person, for example, C, has an intention to harm someone, probably B, but harms another person, A, unintentionally. C will still be liable as the malice or intention automatically transfers. So they don't need to come and prove and say, oh, well, I did not intend to harm or kill A. The fact of the matter is, once you intend to kill somebody else, and to kill B, and instead you kill A, the malice transfers. So you don't need to prove mens rea to kill A. valid defense. Now, there are two general types of defenses. There are those on ignorance, which means the accused did not know what was going on, or they lack the mental capacity, or, for example, they have some disease of which they had no control over what was being done. And then you have the accused is aware that the act is being done, however, they had no choice, or they made a mistake. Mistake should be there. Ignorance or being unaware, it includes defenses such as infancy, automatism, insanity, and intoxication. And those that you are aware of, they include self-defense, duress, mistake, and necessity. So I would not have gone through the offenses against the persons because I don't have much time and there are lots of them, so I didn't put it there. But as we go into the problem question, you will see me talking about some of them and the defenses a little bit more. But I also can try to put together something like a little short worksheet or so and send to you in the group of the offenses against the person's act, since I didn't offenses against the person, sorry, since I did not go through that. So problem questions. We'd have gone through the essays, but we didn't really go through problem questions and the IRAC method. Answering problem questions. Remember, it's not an essay, so no introduction and body paragraphs. The only thing probably on the essay that you will need is a conclusion. Remember, if you see the word advise as opposed to explain or discuss, it's a problem question. If you see explain or discuss or examine, it's an essay. But if you see advise the party, it is a problem question. Criminal law tend to carry a lot of the problem questions. Similarly, when you get to tort, you see a lot of, when you get to year 2, overall, you see a lot more problem questions. And when you get to university, they will kill you with them. All right, so how should it be done? You should use the IRAC or ILAC method. I know that different teachers use a different one or may suggest a different one, but it's really the same thing. If it's IRAC, it's issue, rule, application, and conclusion. And if it's ILAC, it's issue, law, application, and conclusion. Rule and law is the same thing because the rule is the law. The rule is the principle, the rule is the law. So it's the same thing. How should it be done? If the question has 4 issues, you should have issue 1, rule for issue 1, application of principle to facts for issue 1, and conclusion of issue 1. Then immediately after that, issue 2, rule for issue 2, and you continue like that. And after you're done concluding issue 4, then you do a general conclusion. So IRAC, issue, rule, application, conclusion. All right. All right, so as I said, I don't have anything about offenses of persons here because of time, but I noted that the study guide provides you with a good coverage of all of that, and someone did send a virtual copy in the group, so I would advise you to take advantage of that. And then I would suggest that you read and identify the mens rea required for each of the offenses and check if there are any defenses that applies to that offense. So the past paper question. With reference to decided cases, explain what is meant by the expression, the intention, mens rea, and the actus reus must coincide to constitute a crime. You know, basically, it's about criminal liability. If you have one and you don't have the other, they will not work. You must have the guilty man and you must have the guilty act. I won't go too far into that because we've already discussed it extensively. We have discussed both mens rea, we have discussed both actus reus. So I am going to go into the problem part of the question, which is how CXC normally sets up a lot of questions nowadays, where they have a part A and part B, part A being an essay, part B being a problem question. So part B, after a night on the town, Helmut and Ophelia return to their 10th floor apartment. Both are drunk. Helmut dangles Ophelia from the balcony. Much to her delight, she slips and falls to the ground, dying a few days later without regaining consciousness. With reference to decided cases, advise Helmut of his criminal liability. And it's from your 2008 paper. It can also be an essay question, So you have to read carefully if they're saying advise or if they're saying examine, discuss, or any other word that is used for an essay. Issue. Note that you are answering a legal question. Your legal issue must include both law and facts. So some of the issues that I identified are whether by dangling Ophelia from the balcony. I'm so sorry about the bike, some of the delivery guys. So the question is whether by dangling Ophelia from the balcony, which caused her to slip to her death, could cause Helmut to be criminally liable for murder. Secondly, whether Helmut's recklessness in dangling Ophelia from the balcony could make him liable for any other offense of the person, such as manslaughter. And lastly, whether Helmut can rely on intoxication as a defense against his conviction. Rule. Your rule is the law relating to that specific area. You must introduce the topic with a simple definition, and you will appreciate this especially as you move on from the CAPE level, because most of the teachers, some teachers don't really care. They just want you to just go into the issue and just apply the rule, just get to the test or to the case or whatever. But some likes to know that you are versed on the topic. And as Samoya would have come on and said earlier, you must assume that these people know nothing about law. Even if they write your textbook, just assume that they know nothing about law, and therefore you want to at least introduce the area. So you need to ask yourself if there is a clear and well settled, after you have given a small definition, don't make the definition too extensive that it takes up 2 pages, because that's really not the rule. So you need to ask yourself if there's a clear and well settled principle. You need to ask yourself if there's a test, because as you have seen earlier, we went through the Woolen two-stage test. That's a principle, that's the leading case, that's the leading principle. So if there's a test, you want to ensure that you don't skip over Woolen and write some other, or write just the facts of Woolen, or write about 5 other cases and don't identify that there's a test specifically for oblique intention. You want to make a note if there's a leading case. Woolen again is the leading case, so you want to talk about the leading case. If there are any developments on that case, if any new case come and there's a development on the principle, you want to make a note of that. If a new case came and it overturned the original principle, you definitely want to make a note of that. You want to, as I said, well, it's kind of the same thing if there's any new developments on the rule. And you want to, if there are any oppositions to the rule, you want to make a note of that, because there might be a new case that does not necessarily overturn the rule. They might leave it alone, but they might disagree with it. So you want to make a note of that as well. So rule for issue 1. So first I gave remember issue 1 is whether he can be charged for murder. So I gave a little definition. It is a general principle of criminal law that a person may not be convicted of a crime unless the prosecution have proved beyond a reasonable doubt that he caused a certain state of affairs. And I really don't have to go through all of that. And I speak about the strict liability and everything, but where I really wanted to get, that's the definition, but where I really want to, for time, what I really wanted to focus on is when we get to the murder section, which is we're talking about the rule for murder. Oh, and once you put the definition here, you don't put it at every rule. You put it here. When you get to rule 2, or when you get to rule 2, you just move into manslaughter. You don't have to talk about this again, the top part again. So murder, according to Smith and Hogan, is when a man of sound memory and at the age of discretion unlawfully killeth within any country of the realm a reasonable creature in realm, it should be natural, sorry, autocorrect was doing this thing, under the king's peace with the malice aforethought, so that the party who is wounded die of the wound, and so that the party who is wounded die of the wound within a year and a day. The mental element for murder is the intent to kill or cause grievous bodily harm. For one to be charged with murder, the defendant's actions must have caused the death of the victim. See Aaron Smith. I should have put Aaron Smith in italics. That's something as I want you guys to know. Well, you're writing. sorry about that again. So you're writing, so you can't put it in italics, but what I would advise you to do is to underline. So when you write your cases, underline them so that your examiner can see, because this is a source of law. This is your source. This is where you get your evidence from. This is where you get the information. So it must jump out at them when they look on the paper. So you can put in italics, but you can circle or you can underline. Just make sure that when they see your exam paper, your cases jump out at them. So C.R. and Smith, where Parker C.J. noted that the defendant, it should be the defendant's actions must be the operative and substantial cause of death for him to be liable for that debt. This rule will only suffice, though, if there's no intervening event, which we have spoken about, that would break the chain of causation and reduce liability for the defendant. This was explained in the case R and White, where it was held that the defendant was not liable for her murder, as his act of poisoning the milk was not the cause of death. He was liable for attempt. This case established the but-for test, that is, would the results have occurred but for the actions of the defendant? Secondly, the defendant must be a reasonable creature. The victim must have died within a year and a day, and it must have occurred under the king's peace, and the defendant should not have a valid defense. Note that the actus reus alone will not suffice. Defendant must have the capacity to commit murder, meaning they are of sound memory and of the age of discretion. In IM and DPP, the key principle was laid down by Lord Halesman LC, who noted that a man would be held liable for murder even if he had the intention to at least commit grievous bodily harm. However, even if the defendant did not intend for there to be any harm or injury, spelling error right there, if he had the oblique intention, meaning he could foresee that his actions would cause some injury to the victim, then he may be liable for murder. This was explained in R and Woolen, where the key principle is where the foresaw death or serious injury to be virtually certain from his actions, the jury may find that he had the necessary intention for murder. However, R and Matthews and R and Elaine rebutted this, noting that even if the person could see that his actions would result in serious harm, the jury does not have to convict him of murder. Malice, therefore, which is the direct intention for the person to die, remains the main mental element for murder and the main distinction between murder and other offenses to the person, such as voluntary manslaughter. Application of principle 1 to issue 1. Your application is the most fun part. This is because you already have the law above. All you are required to do now is to really just connect your facts from the scenario to the rules that you have already noted. And if there's an objection, I know that if there's an objection to your principle, you must speak about that under this heading as well. And you would have noted that I would have included R.V. Elaine and Matthews, which was which opposed Woolen to some extent in my principle, so I can discuss them here. So the first thing in the application, it should be principle noted, is that the defendant must have the necessary mens rea, actus reus, and a lack of a valid defense to be criminally liable. There are offenses, however, where the government principle notes that knowledge or foreseen risk is not necessary. Therefore, mens rea is not required. These offenses are called strict liability offenses, but they do not apply to the offenses against a person or offenses that cause physical harm to another. Strict liability would not apply in the current case since Elmit dangled Ophelia from the balcony and she fell to her death. His actions resulted in the death of another person. Therefore, the court must look at whether he had the necessary intention to cause death. The issue is whether he can be convicted for murder. The actus reus for murder, as mentioned above, is that his actions must have resulted in the death of the victim, meaning there was no intervening act. Had it not been for Elmit dangling Ophelia from the balcony, she would not have fallen, and therefore it could not be said that he had, that he had the actus reus. However, you must have the mens rea for murder. It cannot be direct as explained in it can be direct as explained in Hayam, where the person wanted to ensure that the victim may die. And there may be oblique intention as explained in Woolen, where the defendant could foresee that his actions would have resulted in the person's death. However, Matthews and Elaine oppose this, noting that oblique intention is not always conclusive in murder cases. Therefore, malice, which is the direct intention, remains a decisive factor and makes a distinction between murder and other offenses. In the current case, it can be said that there was no intention to kill Ophelia. They were both out drinking and decided to behave reckless. This recklessness she agreed to and was enjoying. She slipped and fell, which meant he did not intentionally push or drop her. Therefore, it does not seem like murder, but it seems to be another offense of the person. To the person it should be. Conclusion of issue 1. You will have more than one conclusions, as I had noted before, because you must conclude after each issue. But after you have concluded all the issues, you must have a general issue. So for your conclusion after the specific issue, and this is specific to CAPE, I know your CAPE markers like it because they have said it time and time again. When your conclusion notes, when you ensure that your conclusion is the end of your problem question and your issue statement. So for example, in conclusion, in advising, because the end of your problem question says you must advise Helmut on his criminal liability. So in conclusion, in advising Helmut, it is highly unlikely that he would have been criminally liable for murder. You must make a note of murder now because that is the end of your issue statement. Because while he had the actus, and then you can finish your conclusion. While he had the actus reus, his intention to commit murder is quite unclear. Also, given that there seems to be no malice, which is required in the mental element mens rea for murder, Helmut is more likely to be convicted of another offense of the person, possibly manslaughter. I did not directly say it's manslaughter, and I said possibly. So I gave the presumption, and then I'll have to go into the issue about manslaughter. So rule for issue 2. Remember that the issue for issue 2 is whether Helmut's recklessness in dangling Ophelia from the balcony could make him liable for any other offenses of the person, such as manslaughter. Then I go into what is manslaughter, and then I go into the different kind of manslaughter. But because I can already identify, and having done classification, you should be able to identify different parts of the different areas. You would know that when it comes to offenses of the person, when it comes to being reckless, it's usually involuntary manslaughter. Voluntary manslaughter is usually when we talk about like your health and so forth and so on. So in a person who causes death of another is guilty of involuntary manslaughter if he or she does so either by an act which is unlawful or dangerous, constructive manslaughter, or with gross negligence, or with recklessness. As to the risk of death or serious bodily harm, the test for recklessness manslaughter is subjective. Again, it's not objective. It's not based on the reason of a man. And it depends on whether the defendant had foreseen serious risk that the victim would suffer serious injury or death and took the risk unjustifiably. Now, you can use R.V. Cunningham as your leading case, but I want it because we already talking about R.V. Cunningham. You can put it there. Don't have much time to go through everything, so I just wanted to wrap up. So you can put you must put it there, but there's another case that I gave you that you can also take. One of the leading cases here is R.V. Lidar, and in this case, the defendant had an argument with the victim who was half leaning into the defendant's car and drove off. The victim was crushed by the rear wheel. The defendant was convicted of manslaughter. The Court of Appeal held that in order to be liable, the defendant must have foreseen a risk of serious injury or death occurring and assessed that the risk was at least highly probable to occur. Applying that rule to the issue now, it is evident that Helmut's actions constitute the actus reus of murder. However, as we mentioned above, he had no clear intentions to commit murder, and as such, as mentioned above, he had no clear intentions to commit murder, and as such, it must be assessed as to whether he can be charged with manslaughter. The test to be applied to the current case are give me 1 second, guys. All right, so the test to be applied to the current case is the rule in Lidar, which was explained above. That is whether Helmut could have foreseen a risk of serious injury or death occurring and assessed that risk as at least highly probable to occur. The facts of the case are such that they returned to the 10th floor of the building and Helmut dangled Ophelia over the balcony. He must have seen, one, the risk of getting drunk and then playing or frolicking, and secondly, he must have seen the risk of dangling a human being over a balcony 10 feet up off the ground. When your body is somewhat at a weakened state, or even if he had full strength at the time, Helmut saw and assessed this risk and took it anyway, and as such, he should be liable for manslaughter. In conclusion, in advising Helmut, his recklessness makes him liable for manslaughter, as in accordance with the rule in the DAR, he saw the risk of injury to Ophelia from his actions, assessed the risk, and took it anyway. The final issue, whether Helmut can rely on the defense of intoxication to lessen the criminal charges laid against him. Intoxication, if done voluntarily, is not a defense to criminal offenses. Involuntary intoxication, however, can be a defense if it makes the defendant incapable of forming the necessary mens rea. Involuntary intoxication, especially with drugs or so, if you are smoking marijuana, someone else around you might get high off the marijuana. Because it can happen that way. There can be secondhand smoking and someone else can get high off. But if a defendant had the necessary mens rea, however, committed the same because he was drunk, he will not have intoxication as a defense. This is because the voluntary taking of alcohol or drugs cannot of itself excuse the commission of a crime, and it is not a defense that a person's mind was so affected by alcohol that he acted in a way he would not have done if he was sober, or that he did not know that it was wrong. The only exception to the principle is where there are strict liability offenses, as mens rea is not a requirement. The principle was explained in the case DPP v. Magistrate, where it was held that the rule of common law was that self-induced intoxication was not a defense to criminal charges. That although the rule had been mitigated for offenses where a special intent had to be proved, it was still an effective rule which had not been altered by Section 8 of the Criminal Justice Act, and accordingly, self-induced intoxication by drink or drugs or both was not a defense to the assaults alleged against the appellant. In the current case, neither Helmut or Ophelia was involuntarily intoxicated. They both voluntarily got drunk, and as such, the rule relating to voluntary intoxication will apply. It is unlikely that Helmut will be able to rely on the defense, because in applying the common law rule, which was explained in DPP and Magistrate, voluntary intoxication is not a defense to criminal offenses. Helmut cannot claim that he would not have done this if he was sober, or that he did not know what he was doing. The exception does not apply to him because he dangled Ophelia from the balcony, and this resulted in the cause of her death. Thus, this is an offense against the person and not a strict liability offense. The exception only applies to strict liability offenses. In advising Helmut, he could not rely on intoxication against the criminal charges laid against him, as he was voluntarily intoxicated and voluntary intoxication is not a defense against the person. All right, so that is the end of my part of the presentation. If you have, yes, Javon, I will send it to the WhatsApp group. So if there are no questions, I will now hand over to Samoya, who will do paper 1, the multiple choice questions for you. You're welcome, Javon, and have a good evening, everyone.
Hello, everyone. So thank you, Ms. Morris, for a very informative and well-prepped presentation. And I'm hoping that you guys learned a lot and you guys took the relevant notes, and that after this session, you're better able to apply yourselves, apply your rules and the laws, not the laws, the rules and cases to the relevant questions that you're given coming the exam day. Unfortunately, we don't have a lot of time to do the paper 1 questions. However, don't be disgruntled, because if it is that we're not able to get through all the materials, they will be provided to you via the WhatsApp group, and you'll be able to better prep on your own. So we're going to be looking at the first paper. Unfortunately, not like Ms. Morris, I don't have a PowerPoint presentation, because most of the paper 1 questions that were provided were already marked. And so I don't think it allows you to have any sort of justice if it is that you just are able to see the questions and the answers on the screen. And so I think you guys will somewhat zone out on me before the end of the session, and you guys really would not have learned anything, because you just be provided with the answer. You wouldn't be allowed to be thinking as quickly and on the spot as I would like you to do in order for you to apply yourselves to the exam. I know that most persons will share the view that the multiple choice papers for paper 1, the paper 1 exactly, is somewhat repetitive, and you find most of the questions being repeated over the years because they were pulled from a pool of questions. And so you'll find that not all questions are repeated, but a great lump sum of questions are repeated over the years. So the first paper we'll be looking at is the paper 1 for 2011. I'm going to try to get through this entire paper, and I'm setting a time to be finished with this paper approximately 3:10, so we could move on to another paper and also time ourselves where that is concerned. So once again, I hope you guys are ready. And also, if it is that you have these papers, the 2011 paper, pull it up so that you can either mark it to know the correct responses, or write down the responses, not the letter, not the alphabetical, but the answer itself. So if it is, what is mens rea, and B says the mental aspect of the first element of a crime, then you write down the mental element for the answer mens rea. All right, so let's get into it. No more time wasting. I'm going to be reading the questions, and I'm going to ask for responses. I'm going to read the responses, and then I'm going to ask, you only have Daniel, I think that's the pronunciation. You only have 2017. Anybody else? Anybody has a 2011 paper? Let me see a show of hands or responses in the group, in the chat, I should say. Anybody has the 2011 paper? I could switch to 2017. Anybody has, I'm not seeing any responses. I'm talking to myself. I seem to be having a monologue.
Miss, I can look in the chat.
I'm currently looking in the chat. I'm seeing 3 responses. Okay, let's do the 2017 paper. All right. So please listen carefully. I will try my best to get through majority of the at least 2 papers or 3 papers that I do have. All right, so let's go. It is true to say that natural law is A, is similar to morality and Christianity. B, is a command of the sovereign that must be obeyed. C, is an instrument of social control and public order. And D, must conform to an acceptable code of moral behavior. I'm going to repeat that again. It is true to say that natural law is either A, is similar to morality and Christianity. B, is a command of the sovereign that must be obeyed. C, is an instrument of social control and public order. And D, must conform to an acceptable code of moral behavior. A, B, C, or D you think is the answer? Let me make this clear. For the persons who are messaging in the group, could you unmute your mics and tell me the answer, because I'm not going to be able to be multitasking between the chat and the paper that I'm currently doing. So open your mics. For those of us who are wanting to be attorneys, we're going to have to speak. So open your mics and tell me what you believe the answer to be.
Oh, D, and also I said D, and Ashley, Indiana said D as well.
What is D?
D, Miss.
And
Must
Conform to an acceptable code of moral behavior. But why don't you say it is a command of the sovereign that must be obeyed? Why not B? Humor me. Why not B? Playing the devil's advocate. It's D's the answer. But why could not be any other response?
can you
What is natural
repeat the
law?
responses?
Pardon?
If you could repeat the responses.
A is similar to morality and Christianity. B is a command of the sovereign that must be obeyed. C is an instrument of social control and public order. And D must conform to an acceptable code of moral behavior.
I believe A was reduce the definition of natural law to Christianity, while religion is a source of natural law. It's not the only source. Better yet, Christianity in itself is not the only source. I believe B, something about sovereign command.
Yeah, it's a command of the sovereign that must be obeyed.
Is a command of the sovereign that must be obeyed. While natural law is sourced from, okay, let's say individualistic moralities that is subjected to the person or from a higher being, such as religion, it is usually what shapes the moral system, but not necessarily the rules that are backed by the sovereign. So you have, and I think that is where the differentiation between the rules and the laws would come in. And then I'm not sure what the response for C was. Can't remember it right now.
Okay. All right. You get the basic concept of why it is indeed D. Let's move on. Give me a second. All right. Second, which of the following best describes literary sources of law? before I give the responses, what are literary sources of law? Come on, guys, you know this. Be quick on your feet. What are literary sources of law? Without hearing the responses.
Would that speak to the statutes, which are the laws of the Constitution,
No.
and so on?
No. Literary sources. What are literary sources of law, guys? Javon, I must say you're not completely wrong because the Constitution is considered a literary source. But what exactly is a literary source? Because the Constitution is not going to be on the paper.
Literary or literal?
Literary.
I believe it would be anything that is written in law, so such as books, the Constitution, for example. I'm not sure how to.
Crystal Robinson. Yes. Literary sources describe the location of the law, where the law can be found. So that's why I said to you that the Constitution is indeed a literary source of law. But it is literary sources of law is described as the location where exactly the law can be found. The law can be found in the Constitution, it can be found in statutes, it can be found. So it is the location of the law that is considered literary sources of law, right? Okay, third question. Primary legislation refers to legislation that is what? Primary legislation.
The ones that would have been passed by Parliament.
Correct. So that is C. So 1 is D, 2 is B. So 1 is natural law must conform to an acceptable code of moral behavior. Literary sources of law is the location of the law. And 3, the primary legislation refers to legislation that are created by Parliament as a part of its coherent, inherent function, right? The Parliament was created or was formed to create legislations to govern the country or the particular society, right? 4, the Judicature Act of 1873 and 1875 fused the law and what? The Judicature Act of 1873 and of 1875.
Equity.
Equity, perfect, and that is A. So the Judicature Act of 1873 and 1875 fused the law and equity, right? Specifically, common law and equity, right? Which of the following is not a maxim of equity? 1, equity is equality. B, delay defeats equity. C, he who comes to equity must come with clean hands. And D, equity was created to ease the harshness of the common law.
Miss D.
What?
Miss D.
B,
D.
as in
No,
boy? D as in
as
dog.
dog.
Yes. What are the maxims? What are maxims of equity? All right. Let's get to this paper. 6. Which of the following was traditionally, let me read it again. Which of the following was traditionally the only remedy available under the common law? So before there was equity, right? And before there were things put in place to ease the harshness of common law, what was the only remedy available for a common law? If it is that you violated a rule under common law, what was the only remedy available to you?
Damages.
Correct. And now that we have had a fusion of equity and the common law, what I know, name 3 other types of remedies that are available to us if there's a breach or find ourselves in breach or violated or whatever the circumstances may be. If it is that we find ourselves on the unfortunate end of common law, we have, all right, we need to move quickly. We have injunction, we have rectification, and we have specific performance. Good, Javon. Injunction is one. Rectification is another. Specific performance is another. Prohibition is another, right? 7. So that is A, damages for 6. 7, what is the main difference between the High Court and the Magistrate's Court? And I don't even need to read the responses because you should know the functions of the High Court, and you should know the High Court is also called the Supreme Court for Jamaica. In Barbados, it's known as the High Court. The Magistrate Court is the RM's Court. So what is the responsibility or what is a characteristic of the High Court? Appellate jurisdiction is at the appeal court. Appeals are not heard by the High Court. Appeals are heard by the Court of Appeal, right? But what is unknown or what jumps out at you when you hear of the High Court or the Supreme Court?
Mr. Want the answer?
Yeah.
For that question?
Yeah, the answer in general.
Cases in the High Court are primarily tried by a judge and jury.
And a jury. In the resident magistrate's court, the cases are presided by a judge, a resident magistrate judge, right? But in the High Court, it is tried by cases are primarily tried by a judge and a jury, right? So 7 is D. 8. Which of the following are reasons a person may be discharged from jury service? 1, illness. 2, criminal record. 3, ignorance of legal terms. So is it A, 1 and 2 only, B, 1 and 3 only, C, 2 and 3 only, and D, 1, 2, and 3? So 1 is illness, 2 is criminal record, and 3 is ignorance of legal terms. How art? Let me pull your brain. A juror is allowed to turn down or be exempted. Let me not say turn down, because we're not allowed to turn down if we're called to be jurors, right? A person called to perform jury services can only be exempted if it is that they are public officers or they operate a public office. So whether they're ministers, they're police officers, soldiers, doctors, nurses, teachers, lawyers. And also, if they are sick, whether physically or mentally, or if it is that they have a criminal record. So if it is that you are a member of the this is a specimen paper, guys. So if it is that you are a public service worker, or you are ill, whether physically or mentally, and you have a criminal record, that are some of the only reasons you can be exempted from serving on the jury, right? So the answer has to be illness and a criminal record. Ignorance of the legal terms or ignorance of the law is not an exemption to not be able to sit on a jury, right? You have to either be sick, or you have a criminal record, or you are a public service worker. So that is A, 1 and 2 only for 8. 9, John and James recently had an intense argument in which John asserted, I bought this property with from the government a long time ago. It is mine, right? John and James recently had an intense argument in which John asserted, I bought this property from the government a long time ago. It is mine. The area of law in which John's action will be pursued is guys, this is too easy. I don't think you have to read the responses. John and James are arguing over land, about who owns the land. Under what area of law is he going to bring a claim?
Private.
Private law. Public law, no. Criminal, no. Constitutional, no. It has to be, it's a private matter between two private citizens about their own private property, right? So it has to be private law. So that is B for 9. 10. A policeman gives a traffic ticket to Miss Benjamin, a lawyer, right? Miss Benjamin feels that she is being unfairly treated and vows to have her day in court. In which of the following jurisdictions is the action most likely to commence? So at which court level is Miss Benjamin going to have her day in court at? At which level, court level, is she going to?
Court.
The what?
Magistrates.
Okay. Why not you know what? Why not the Privy Council?
Well, that's the highest court. I don't think she'd be going there for a traffic ticket.
Okay. So the Resident Magistrates Court, and that is C for 10. 11. Zinga, a victim of domestic violence. Sorry, I'm getting a call, but I'll have to end it. Not right now. Sorry, guys. So, 11. Zinga, a victim of domestic violence for 25 years, is charged for killing her abusive husband by putting poison in his food. Which of the following describes the nature of Zinga's case? So Zinga, a victim of domestic violence for 25 years, is charged for killing her abusive husband by putting poison in his food. Which of the following describes the nature of Zinga's case? Right off the bat, so we can move on.
Criminal.
Pardon?
Criminal.
Great. 11 is B, criminal. 12. The judge in sentencing the defendant said to him, be careful of your associates. There was no evidence, however, that the defendant's association with these persons affected the judgment in the case. I'll read it again. The judge in sentencing the defendant said to him, "Be careful of your associates." There was no evidence, however, that the defendant's association with these persons affected the judgment in the case. The judge's statement may be described as what?
Obiter dictum.
Great. And what is obiter dictum, guys? These Latin phrases. What exactly is that?
Essentially, it's something that was said, usually in judgment that doesn't impact the judgment, but it was just said by the justice because I suppose they just want to chat. I don't know.
It's
Yes,
normally a statement.
or it could be a judge's expression of opinion uttered in the court. I don't know.
That's a very booky answer. However, in layman's term, it's something judges say by the wayside, right? It has no influence on the judgment itself, but it's probably a personal feeling expressed by the judge in regards to the case. It has not affected the outcome of the case, or anything like that. It's just merely thoughts from judges that are said by the wayside when in cases. It may be at the end of giving his judgment, that they just say these things. And this is a perfect example of obiter dictum, in the sense that him saying to you, "Be careful of your association," is not saying that your company is wrong. It's just his thoughts, right? And you can't beat a man for having an opinion. So 12 is B. 13. John, who is John, who is before the court on a charge of murder, discloses to his attorney that he had committed the crime. His attorney becomes very perplexed and is not certain what to do. The attorney's first duty is to who or what? If your client confesses that he committed a crime, you as an attorney, who is your duty to?
The client.
The court.
The court.
Your duty is first and foremost to the court. Hence, is a very good reason as to why lawyers who practice at the criminal bar chooses to not know or choose to not know whether you are guilty or not guilty. They will ask you, what do you plead? Or what do you want to plead? It's not probably what exactly happened, but how do you want to plead? Guilty or not guilty? Because if it is that you admit to committing a crime, it is the attorney's first and foremost above all duty is to the court of law, right? So he has the attorney's first duty is to the court. So 13 is a C. 14. Which of the following are features of delegated authorities? 1, flexibility in the court system. 2, special knowledge from experts. And 3, greater autonomy to administrative units. 1, flexibility in the court system. 2, special knowledge from experts. 3, greater autonomy to administrative units. A is 1 and 2 only. B is 1 and 3 only. And C, 2 and 3 only. And finally, D, 1, 2, and 3. Which of the following are features of delegated authorities? What are delegated authorities, guys?
This is the answer: special knowledge from expert and greater autonomy to administrative units.
Okay. But answer my question as to what are delegated authorities? Jada. What I don't want, guys, it's all good and well to get the answers, right? But you have to know how you arrived at that answer. So what is delegated authorities?
Miss, is it like separation of powers?
No.
Okay.
I think it's something having to do with increasing productivity in the courtroom, or efficiency rather.
No. No.
So division of no, it's not okay.
That's not.
Miss Woody has something to do with the division of labor, the decision making within the courts.
Why you guys keep saying the courts in particular? Why you guys keep saying the court? But no. Features of delegated authorities is when a particular public officer or person in power gives their power to somebody else to have the power to perform a particular duty that is fundamentally their own, or by law their own. So if it is that you have let me try to give you a good example. You have a commissioner of police, right? You have a commissioner of police. So he can delegate his authority or delegate some of his duties or power to a deputy commissioner, right? Give me a second, guys. I have to reply to this message. Give me a second. But based on what I just said, I want somebody to explain to me what exactly is delegated authority. So give me a second. All right, I'm back, guys. So in layman's terms, delegating authorities or a delegating authority can be a commissioner of police giving some of his power to a deputy commissioner of police to perform a particular duty. Is that understood? I'm talking to the...
Yes, no.
Okay, I need responses, guys. I have a very interactive personality, and I can't sit and talk to my tablet and not get a response. Give me a second, guys. Guys, I'm very busy. I'm awfully busy. Student leadership is not an easy road. But don't ever shy away from student leadership in particular. It prepares you for the world. So I hear. All right. So moving on. Give me another second, guys. Another second. But the answer to 14 is 2 and 3 only, which is special knowledge. And I think it's J. Let me not try to pronounce people's name and get it wrong. So it's 2 special knowledge from experts, and 3, greater autonomy to administrative units. That's the answer for 14, right? Give me 30 seconds. I have to reply to this message there. Let me explain to you guys. I'm currently supposed to be in a meeting now, but I'm here, so I have to be trying to multitask, and I'm heading a committee that I'm supposed to be there for, so they're asking me questions. So give me 30 seconds. All right, guys, 15. John and Mary are going through a divorce, right? They are both seeking custody of their 2 children, Maria and Jim. They're meeting with an independent third party who is assisting them with the settlement. They're both engaged in the process of what?
Mediation.
Mediation. Why you say mediation? It's correct, by the way. Let me not get you wrong. It's correct. But why not arbitration? What's the difference between arbitration and mediation?
I believe arbitration is someone from the court, while the mediator, as I said, is a third party. So the arbitrator would function more like the judge, and they would decide the outcome of the dispute based on the evidence that is provided. However, mediation would look at an approach. Basically, everybody coming to a consensus about the remedy that they want for the issue at hand.
Along the right line. Mediation is a third party agreed by both persons, but the decision from the third party is not binding by the court. It's not a binding decision. They don't have to take it, right? Arbitration, when an arbitrator makes a decision, it is binding, legally binding. So it binds both parties. So they have to agree that if it is that they don't follow the instructions or the decision of the arbitrator, they can face consequences from a legal point of view, right? So the answer is 15, mediation, and that's B. All right. 16, the fundamental rights of an individual is entrenched in what?
Constitution.
Constitution. 16 is B, the Constitution. 17, 2 ways in which the independence of the judiciary is guaranteed are that judges are what? And I don't even want to read the responses because this is something that you must know by just hearing the question. I will read this again. 2 ways in which the independence of the judiciary meaning the judges, is guaranteed is that judges are what? What are judges?
What are judges?
All right, let me read the question again. I probably phrased that wrong. 2 ways in which the independence of the judiciary is guaranteed are that judges are.
Their pay is fixed. So it's not to the will of any other branch of government to.
They are paid out of what? It's called there's a thing that there are a fund that.
Consolidated fund.
Consolidated fund. The second one is what?
There's a second one.
Yes.
Oh.
2 ways.
Oh.
The dismissal of judges are what?
It speaks to the dismissal of judges.
So a judge
Um,
can only be dismissed on what? Three main grounds, guys. Three main grounds that judges can be. So the two ways is that they're paid out of the consolidated fund, and that they can only be dismissed on three main grounds. One, the age. Two, for disciplinary actions, they have broken the law, whatever the circumstances, broken the code of conduct, or three, they fall sick, whether mentally or physically, right? Only three grounds. So that is A, paid out of the consolidated fund and are only dismissed on three main grounds. 18, constitutional law refers to the law governing the relationship between the constitutional law refers to the governing relationship between what, guys? Or who?
The individual and the state.
Perfect, Torian. The state and the individual. That's the basis of constitutional law. What is it? And that 18 is D. 19. What is the essential meaning of the doctrine of separation of powers?
the executive, legislature, and judiciary are to remain separate.
They have clearly
Different functions and roles.
clearly defined and distinct rules. Which two arms of government can be considered an overlap, or can sometimes run into each other? Which two bodies, or which particular power, or where did my brain just go? Give me a second, guys, to grab this brain of mine. I just lost what I was saying.
Yes,
the arm of government, the three arms of government, right? Which can be said to have the true independence of all three.
The judiciary.
Because you have executive members like the prime minister, the minister of the opposition leader, and stuff who are also a part of the legislature, right? The prime minister is also a part of the legislature and is also a part of the executive. So you find that there's no true independence or separation of powers between the legislature and the executive, because you have an individual who has influence on both powers or both sides. Is that understood? So judges have the true independence because they should not be influenced by anybody but themselves and the law, right? Is that clear?
Yes,
Is that clear, guys? All right, 18 is D. 19 is C. 20. An independent judiciary is indispensable for the protection of the right to what? An independent, what was that?
A fair hearing.
Fair hearing. Good job, Jado. 20 is A, a fair hearing. 21. And the only reason I'm avoiding, and if you can pick up, I'm avoiding reading the responses like A, B, C, and D, because I want you, when you see the question, you only have one answer in mind. And the one that I said, right? And the one that we all agreed on. So you have no other answer. So when you look at the question, you're looking for that particular answer, right? So 21. Which of the following is a principle of the rule of law? What? When you talk about rule of law, it's always the slogan.
And your wholeness is above the law. I'm sorry. No one is above the law. No man is above the law.
We have a comedian. All right. So 21 is indeed B. No one is above the law. 22. Ultra vires refers to what? When someone asks ultra vires.
Contravening the prescriptions of the Constitution. So if it's ultra vires, it will be null and void, or be made null and void through the Supreme Court.
Parts of what you said is true, but you've not said what I want you to see as it relates to ultra vires. It's very simple. Take away the terminologies and the fluff of it all, of what you just said, and tell me pinpointly what is ultra vires. When someone asks ultra vires, what do?
They don't act in their cause.
Exactly. When someone acts ultra vires, is that they're acting outside the scope of their authority. So an administrative body or the judiciary, the executive trying to perform judiciary functions, or the executive trying to perform judiciary functions, or stuff like that. So an administrative act without legal authority, you have no jurisdiction. That is not your cup of tea. That's not what you do. Stick to what you know. Stick to your own roles and responsibilities. So acting ultra vires is when someone acts, or when an administrative act is done without legal authority, right? So the answer for 22 is D. Javon, you were right on point, but I needed you to say the fact that this particular individual is acting outside the scopes of their authority, right?
Okay, understood.
Great. All right. 23. Which of the following prerogatives, orders, is used to compel the performance of a public duty by a public authority? Which of the following prerogative, orders is, what was that, darling?
Mandamus.
Mandamus. Mandamus, darling. But yeah, you're correct. All right, so 23 is mandamus. All right, 24, we're getting there. Slowly but surely. The broadcasting authority, a public body, decides to indict a finance manager on charges of corruption. Which of the following rules should be the authority observe if the dismissal is to be deemed lawful? So the broadcasting authority, a public body, decides to indict its finance manager on charges of corruption. Which of the following rules should the authority observe if dismissal is to be deemed lawful? 1, give reasons for the decision. 2, consider the manager's ability to get another job. And 3, ensure that the cause is judged by an independent persons. So 1 is to give reasons for the decision. 2 is to consider the manager's ability to get a job, another job. Or 3, ensure that the cause is judged by an independent persons. By process of elimination alone, you should know that nobody cares about your ability to get another job. Nobody cares, right? So it has to be the very foundation of letting somebody go from the job is that you make the person aware of the decision or why it is that you made a particular decision. And 3, it must be judged from somebody who is an outsider, who is seen as an independent person or independent persons. So the answer for 24 is 1 and 3. 25. The police acting on a tip takes Kane into custody and forces him to make a confession. Kane requests the presence of an author. What am I saying? Let me read it again. The police acting on a tip takes Kane into custody and forces him to make a confession. Kane requests the presence of an attorney, but his request is denied. The police is infringing on Kane's fundamental right to what? Wow. Silence.
How do you phrase it? Fair and equitable treatment, no?
You said protection. Take the protection. Protection of what?
Protection from arbitrary treatment.
An attorney is what? A representation of what?
The court. The court.
Mercy. The representation of the court, yeah. They're protecting
the law, okay.
The law. So yeah. The fundamental right to the protection of the law, to the protection of the law. You always remember your fundamental rights. But the right to an attorney is the right to the protection of the law, right? So 25 is A, protection of the law. 26, Bert feels correctly that he has been dismissed because of his religious persuasion. He decides to bring an action against his former employers for a breach of his constitutional rights. Bringing this action is, and I'll tell you guys this because we need to move on. And you guys aren't giving me answers at the speed I need to move on to another paper.
Freedom of religion being infringed.
Freedom of religion, it has been infringed. So it's bringing a constitutional claim or constitutional claim based on the fact that he was denied his freedom of religion, right? So 26 is C, in Bert's favor, because his constitutional right to freedom of religion has been infringed. 27, the head of state refuses to appoint a senator nominated by the prime minister. He argues that the people in a general election rejected this individual. The decision of the head of state is, does the head of state? Ultra-vires. Perfect. Thank you, Torian and Javon. Ultra-vires. So the head of state is acting outside of the scope of his authority. The Attorney General Samoya, the Governor General, has a ceremonial rule, right? He's a representation of the Queen. However, the Prime Minister has a responsibility to nominate a senator. However, he has to make the head of state, which is the Governor General, aware of his nomination, right? However, the senator, the head of state, cannot deny or refuse to appoint this person based on the fact that he's saying that the person does not have a popular vote from the people. Nobody cares about the people's popular votes when it comes to senators, right? So that is acting ultra-vires, and that is 27, and 27 is A. 28, which of the following is not a ground for judicial review? A, a breach of a defendant's right to a fair hearing. B, delegate has wrongfully delegated a power given to him. C, defendant is dissatisfied with the custodial sentence imposed on him by a judge. And D, magistrate imposes a sentence that it exceeds the provision for the offense in the statute. See? So C. Why not D? Magistrate imposes a sentence that exceeds the provision for the offense in the statute. All right. Judges, I don't want to say judges have a free will, but you ever watch Law and Order or How to Get Away with Murder or any of these really, really good criminal or whatever court scenes, and the judge say, this is my courtroom, right? Judges are at liberty when it comes to certain sentences to apply their discretion, something called a judge's discretion. So we have in the law where there's a minimum sentence for a particular crime, right? But a judge, what that is saying to a judge is that if the minimum sentence can be 5 years, a judge can't give you 4 or 18 months, right? It has to be within, above the minimum. But a judge can give you life in prison if it is that they find through their discretion. And that's why we have something, when you get to faculty, you learn about something called not abusing your discretion. But a judge has the discretion to apply a sentence based on what they see will fit, is most appropriate for the crime committed, right? So 28 is C, indeed, that the defendant is dissatisfied with the custodial sentence imposed on a judge, on him by a judge. So 29 is C. 29 is the fire service has for the past 20 years given study leave to junior officers to pursue an associate degree. Alex, a fire officer, applies for study leave to pursue an associate degree, but is refused by the chief fire officer. On what grounds may Alex challenge this decision? I'll read it again. The fire service for the past 20 years has given study leave to junior officers to pursue an associate degree. Alex, a fire officer or fire associate, a fire officer applies for study leave to pursue an associate degree, but is refused by the chief officer. Right? On what grounds can or may Alex challenge this decision?
A breach of legitimate expectation.
Perfecto, Jada. Yes, or Jada. Why am I mispronouncing your name? Yes, breach of legitimate expectation. Perfecto, great. We're coming down to it, guys. 30. So that is 29, D as in dog. 30. Mr. Justly, a Court of Appeal judge, has decided to run for political office. His friend, who is also a judge, advises him that he cannot continue to function as a judge while being a political figure. Which of the following issues is now confronting Mr. Justly?
Separation of powers.
Great, separation of powers. So 30 is C as in cat. 31. Which of the following criminal offenses does not require a mens rea to be present?
Strict
A,
liability.
Strict liability.
look at these bright students. I don't even need to read responses. Perfect. I hope we have this going into 45. Great. All right. 31 is D, strict liability. 32, recklessness occurs where the defendant, give me an answer for that. 32 is what?
Doesn't consider the degree of danger that is probable possible.
Great. So he shuts his mind to the possibility of danger. So 32 is D. 33, in the law relating to rape, a man is guilty where he has sexual intercourse with a woman and 1, is reckless as to whether or not she consents. 2, she consents. Or 3, he reasonably knows she is consenting.
Any answer without 2?
Great.
No, 1 and 3.
1, miss.
1 only.
Javon, if it is that he reasonably believes, it is 1 and 3, guys. Let me tell you why. Nobody cares about whether you reasonably believe that she's consenting. She has to give her consent. It's either she's consenting or she's not. Nobody cares about whether you believe that she's reasonably consenting. She has to consent. Consent and rape is a very serious crime, right? And so that's why the requirements are so strict and rigid and sometimes can be on the harsh side. But what I'm saying is that she has to consent. Can I have sex with you? Yes or no? Are you consenting to having sex? Yes or no? If it is that in the middle of having sexual intercourse, she withdraws this consent and you proceed to still perform sexual intercourse, you will be charged with rape. So it is 1 and 3. Is reckless as to whether or not she consents, or 3, he reasonably believes she is consenting. She has to consent, point blank, period, right? So 1 and 3 is the answer for 33, and that is C. Let me close my windows from the screen. Oh. All right, sorry guys. My past paper still suffering. That sucks. Anyways, moving on. Guys, I'm trying to let you guys out of here by end of this paper because we're hitting, I was to hit 4 o'clock. But I promise to send you all the questions so with the answers. And you don't have to worry, these answers are correct. I did get a 1, all A profile in both units. So I kind of have them standing. So 33 is C, 1 and 3 only. So 34. Which of the following offenses involves stealing accompanied by violence? When you steal somebody's thing,
Robbery.
robbery. Oh Lord have mercy. Tiana Lee. Are you in the group, the WhatsApp group? No, you're not. Before you leave, private message me your number and I'll send it to you personally. Is that okay? Yeah. Okay, great. Just private message me your number and I'll take it down and I'll send it to you. However way you feel best. WhatsApp, email, Instagram, personal delivery. I don't know. However you find is most appropriate. All right. So 34 is robbery, and that's B. Inchoate offenses refer to offenses that are what? I won't even read anything else. Inchoate offenses are referred to
Incomplete.
what? Great. That's A. 35 is A. Are incomplete offenses. Name an example of an inchoate offense.
Aiding and abetting.
I'll go back into my brain. Aiding. How is that an inchoate offense?
It's attempt.
Anything attempted, attempted robbery, attempted rape, attempted murder, anything attempted is inchoate offenses. They're incomplete offenses. Okay, got it, Tiana. Tiana Lee. All right. Inchoate offenses are anything that are incomplete offenses. So attempted murder, attempted rape, attempted robbery, attempted breaking and entering, and anything attempted is considered inchoate offenses. They're incomplete offenses. 36, and that is 35 is A, incomplete offenses, right? 36. The most appropriate defense applicable where the accused killed the victim due to a sudden and temporary loss of self-control is what?
Provocation.
Provocation. Perfect. 36 is A. 37. The theory of retribution endorses as a penalty for the crime of murder. The theory of retribution endorses as a penalty for the crime of murder is what? It is a what?
The death penalty.
Capital punishment, right?
Yeah.
So capital punishment. All right, so that is B. 37 is B, as in boy. 38. Which of the following is a theory of sentencing? Why is it that they said that their theory, I don't know if it is the right theory or if it makes sense or if it works, but what's the theory behind sentencing?
Apparently rapists are supposed to be rehabilitated back into the system. So rehabilitation.
Yes. Yes. What was that?
Never mind, miss.
Okay. Rehabilitating offenders. So 38 is A as in apple. 39. Doman entices Paral to buy a car that he claims is free from encumbrances. Paral later finds out that the car is mortgaged to a financial company. Doman was charged with obtaining money by false pretenses. Later, it was discovered that the document was void in law as an unregistered bill of sale. On which of the following grounds would a court be inclined to quash the man's conviction? Give me a second, let me read that book. Go ahead.
Oh, I was gonna ask to read it over.
So Daman entices Paral.
Oh yeah, that's what I said. Oh.
What was that?
Oh no, I was saying I was going to ask you right before you said you were going to.
Oh, okay. The man entices Peral to buy a car that he claims is free from encumbrances, right? Peral later finds out that the car is mortgaged to a financial company. The man was charged with obtaining money by false pretenses. Later, it was discovered that the document was void in law as an unregistered bill of sale. On which of the following grounds would a court be inclined to quash the man's conviction?
Miss,
The answer is, go ahead, Torian.
Miss, there was mens rea, but the actress rea was not present.
Perfect. And I always use a case of R and Dello, so you can look that up and come back and tell me what exactly the case said. But if you want to remember 39, look at R and Dello. 40. So 39 is A as in apple. 40 is that Trevor, a pickpocket, reaches into Tracy's pocket to steal her purse. He changes his mind after pulling the purse to the edge of her pocket. Tracy realizes what happened and calls the police. For which of the following offenses is Trevor likely to be charged? Which offense can Trevor be charged with?
Miss, could it be attempt?
Attempt. So it would be attempted, I don't know, because it can't be robbery because it wouldn't be, my thing is that if it is that there was no violence involved, would it be attempted stealing? It can't be robbery. Anyways, so 40 is B, as in boy. 41, an assault is different from a battery in that an assault is what? What is assault described as that makes it different from battery?
Words uttered to put one in fear of their life.
But there was no
But there's
what?
no physical.
No physical damages.
Great. So that's what differentiates an assault from battery. Battery includes the victim being put in fear of an imminent danger or the fear of battery happening, but there is no actual physical contact. So that is 41, D as in dog. 42. Which of the following is correct? Alpha what's his name? Alpha, whatever that word is, Alpha Adolfi is guilty of murder, where he announces that he's going to poison one, but one is already dead. B, one learns that Adolfi wants to poison him and he dies from a heart attack. C, he keeps the poison at home from where Marcus steals it and poisons Betty, who dies. Or D as in dog, which says he leaves a glass of milk laced with poison for one to drink, but Marcus drinks it instead and dies. What's the answer?
D, miss.
What was that?
D.
D as in what? Boy?
D as in dog, miss.
Dog. And what topic does this come under?
Oblique intent.
Or what?
Causation.
No. Transferred malice, guys.
Yes, the whole word.
Great. So 42 is D, and that topic is transferred malice. 43. Which of the following cases results in battery? No, what am I saying? Which of the following cases results in burglary? Burglary, right? The burglary, whatever. So breaking, whatever. Which of the following cases results in burglary? So A, Albert breaks a window, climbs up a ladder to Ajay's house, but changes his mind when he hears the police siren. B, Donald enters his neighbor's house, believing he had entered his own house, and gives Robert his neighboring Ming vase. C, Mary expects her boyfriend Keith to enter her bedroom through the window. In error, she invites Paul, whom she saw outside, and he steals her jewelry. D, Tom mistakenly enters his house, his neighbor's house, and upon discovering the mistake, steals a painting and leaves. Somebody tell me the answer for 43.
C.
It's in cat. Right? Burglary is C. Why?
All the others are unintentional, but this one he knew he wasn't the person and he still entered and he stole from her as well.
No?
No?
No. Good try though, good try. Good try, Brittany. Brittany. What's very important for burglary is that the owner of the house, she invites him. He was invited. So he has the permission to be there. But then he steals her jewelry, right? So the error is that she invited him. He never broke in, forced entry, or broke anything to get in. He was invited inside by the owner of the property. So it is the invitation, the permission to enter, and then he steals that is constituted burglary, right? So 43 is C as in cat. 44. Brian shoots Marlon in the chest. Marlon had a prevailing heart condition which speeds up his death. Brian claims he's not liable for Marlon's death. Brian is what? Is he liable or not liable?
Liableness.
Why?
Miss, based on the thin skull rule.
Big of you, yes. I wanted you to say the thin skull principle. Go ahead, continue.
Miss, based on the thin skull rule, you take one as there, or take the victim as the.
Perfect. He's liable for the death of the victim because the thin skull eggshell principle states that he must take the victim as he finds him. Nobody cares. The court does not care if he had a prevailing heart condition. Had you not shoot him in his chest, would he have died from his prevailing heart condition? You don't know. But it says that it speeds up his death. Yes, it's a contributing factor, but you shot him. So if you shot a half-dead man and kill him, you still liable, right? So the eggshell thin skull principle, and that can be found in R and Jordan. You have to take your victim as you find him. And
well, I mean, hypothetically or theoretically, I'm supposed to just go right now to my annoying ass father, and who is crippled, and just smack him, and he's already next door to death. Why must I be held liable? I was just helping him to reach heaven, like closer to God. Like, hello, come on now. I don't understand. I think the law should look at things like that. Because if I'm helping my father really to reach happiness, which is God, and being with God, his creator, like, Lord knows.
I'm over you, Javon. I'm over you. Anyway, applying the eggshell and thin skull principle, it specifically states that one has to take the victim as he finds him. 45 and final. Jada is crazy. All right. Which of the following is a case of incitement? What is incitement, guys? Somebody tell me the answer for this. Hold us off. Don't disappoint me now. You guys have been doing well thus far. What is incitement?
Miss, like you urging someone to behave unlawfully or provoking unlawful behavior.
No, darling.
Is it basically soliciting someone to commit a crime,
No.
therefore inciting them?
Incitement in criminal law. Criminal law. Javon,
To
this is
encourage
you.
someone to commit another crime?
No. Javon, this is you. Based on the scenario given here. You give your half dead. Based on your scenario. I know we all want to be political correct. Don't drag me in these streets. Based on the remarks you made previously, right, about the situation with your father, you, Javon, give your father some poison to let him get to heaven and meet his savior more quickly, right? Right? And the poison is not sufficient to kill anyone. That is incitement.
Oh, okay. Thank
You
you.
say encourage them.
So if you wanting to commit a particular crime, but not using enough force to commit it. So if it is that you give the man some poison that can barely kill a rat, then that won't work. Give me a second.
Wait,
You know, I'm very stupid. Guys, you stand corrected. You stand corrected. You stand corrected. But based on the scenario given, but my thing is, incitement is that. But based on this scenario, it can't be X and Y plan to steal A's purse, or X lends Y a gun to kill, and A is already dead. Oh, I missed out a very important part of it is indeed D as in dog, 45 is indeed D as in dog, but X gives Y poison to kill A. So X is the one who gives insights, guys, encourage somebody to commit a crime, like you rightly said, and I stand corrected. Gives Y poison to kill A, but the poison is insufficient to kill anyone. That's incitement. Everybody understood?
Yes,
We get it?
miss.
Great. All right, guys. You guys have been here long enough. I just got here and I'm tired. And I've not had a meal from there. So we're going to, like I said, we would not be able to get through as much as I'd want to. We're coming up shortly on the last 10 minutes of the session, but I'll end it there. And I will, as I promised, to send you by the end of the day the other papers that I had intended to go through with the answers, so that you guys can practice. And if it is that you guys disagree with a particular response that I gave, that you can call me or message me, and I will seek to clarify that which you have asked about. So is everybody Why everybody and the father give me the number? Javon is crazy. Daniel, I was supposed to take your number. Oh, sorry, I'm not talking about you there. No need to apologize. No need to apologize. Let me take your number real quickly. Okay, I'm gonna shoot you a message right now to confirm that I made the correct, I saved the correct number. Give me a second, guys. I'm about to say, do the closing remarks and do the benediction. All right. Brittany, look out for a message. I'm going to message you right now to confirm that. Why is this phone acting up? Gosh. To see if that's actually the number. You got the message? Brittany. Yes,
Yes.
I did. You got it?
Oh, no, I didn't.
Somebody type in. Somebody type in. Support this type in. Brittany, why did I just save Brittany's name as Daniel? Daniel, I'm so sorry. My apologies. Guys, I'm blaming it on lack of sleep and the fact that I'm hungry. All right, guys, I'll correct that. But you guys are most welcome. If it is that you guys have any questions further to this session about whether it is paper 1 or paper 2, I know, right? What's up with this miss thing? Gosh. Anyways, if it is that you guys have any follow-up questions, feel free to message me. And I'll try my best to help you out. I wish you guys all the best in your exams. You guys will do well. And I know that you guys have what it takes to, if it is that you guys want to actually move on, that you have what it takes to conquer that, which is the devil of faculty. So good luck in your exam, and I wish you guys all the best. Bye, guys.
Okay, thank you, Samoya. Same